attachments of Manish Mittal yesterday. My lord, my senior's name has not been recorded. Mr. Somraj Jain's name is not appearing, my lord.
To be mentioned, that is in the appellate side.
Appellate side.
To be mentioned the other. Right.
Yeah.
My lord, may I be permitted to mention
Grateful.
one urgent matter, my lord? This is, my lord, credit card fraud, my lord. Subsequently, they are sending muscleman, my lord. I mentioned it, my lord. They are sending muscleman every day, my lord. My lord.
Well, may I be lordship kind if to mention a matter, my lord?
Yes.
Well, the urgency tender matter, my lord, for decommissioning of a thermal plant by DVC. My lord, uploaded documents on the 20th of May, my lord. Yesterday evening, we get a mail saying that one document, which is the irrelevant document, which is the integrity pact, which is like an indemnity, it is illegible, so you are not eligible, so you cannot participate. Tomorrow is the last date for deposit of EMD. I've told them that the EMD and day
The
after.
matter is in the list.
No, my lord, we are filing it today, my lord. Yesterday we got the mail of rejection.
Leave granted tomorrow, 10:30.
Grateful, deeply obliged.
10:30. Yes.
This extension of interim.
Extension should have mentioned yesterday.
I had mentioned these matters I have been mentioning from 26th, my lord.
কেন এগুলো আসে না?
My lord, requisitions have been sent repeatedly, my lord. It is not.
এগুলো আসছে না, বারবার repeatedly mention হচ্ছে, সেগুলো বল।
Requisitions have also.
We are sending requisitions, Mr. Lahiri. We have nothing else to do. I have to personally then go to the department. Yes, Mr. Bhattacharya.
Forgive me.
No grant, not grant. What?
An extension of interim.
No extension I should have mentioned.
No,
Yes.
it is my
No,
mistake.
Mr.
7th of July, my lord, it
No,
is
I cannot
ending.
make an exception for it.
7th of July, it is ending. My lord, I will suffer.
What is the nature of the interim order?
But the interim order is not to demolish the structures.
Hand over. Call on the list.
Great.
Thank you.
Madam, may I be permitted to mention one, madam? This is basically a group 1 matter, my lord.
It is appearing in my list.
Yes, my lord.
Hand over to you mentioned Kalke for release. To be mentioned থেকে হ্যাঁ to be mentioned গুলো ডেকে দিয়ে তারপর 10:30 যাবো।
To mention item number 1 for release.
Yes.
My lord, this pertain to the group 1 matter, my lord. Kindly
Oh,
release
achha.
for want of determination, my lord.
Let the matter stand released from my list due to want of determination, with liberty to the parties to mention for inclusion before the appropriate bench having
My lord,
determination.
A form should be corrected, my lord.
Achha, leave is granted to the learned advocate on record for the petitioner to correct the A form annexed with the writ petition.
My lord. My lord, I am just tendering my unconditional apology, my lord. This is not appearing in the list.
কি বললাম ওটা?
This is a.
This has been filed for my court.
Yes, it is filed wrongly in the group 9.
ও আচ্ছা আচ্ছা। The একই থেকে রইল। It will appear as to be mentioned. Tomorrow if the file comes today.
To mention item number 2 and 3.
Yeah, I'm very grateful, my lord, for the opportunity.
Yes.
Well, just, my lord, 5-7 minutes, my lord, not more than that. Well, lord, may I request your lordship to kindly take up, my lord, rule 370. 370, money? 15370. Well, lord, the volume 2.
Kindly note that your lordship on 30th June, my lord, had hearing is concluded and judgment is reserved.
I know, my lord, I had mentioned it.
Order to that effect also passed, my lord.
No, Mr. Shah, what are you trying to mention? I mean,
My lord, no, I'm not going to rely on any new document. My lord, 2 or 3 things, but in the context of my learned friend's submission, that my lord, 29% your share in the earlier joint venture, which is what you can get. So out of 68 crores, only 29% must be credited to for your purpose. Only that clarification, it is there on the documents. I have not, my lord, drawn your lordship's attention to do the documents. Just 3 documents I want to show you, lordship.
give me the pages, Mr. Shah.
Yes, my lord. My lord, the
Just give me
first
the
page is, my lord, page 684, which is the joint venture agreement.
Yes.
Then, my lord, I'll show you, lordship, the document that we submitted, that is 677. And then, my lord, the RVNL clarifications, which are at 681, 682, and 690.
681, second matter.
This is clarification regarding which point? 29%?
My lord, this is, my lord, clarification. This clearly shows that, my lord, the payment made to me is the 29%, my lord, value. Well, that is all I show. And I also have a, my lord, payment certificate, my lord, which, my lord, I have, my lord, got on
No
record.
further document, Mr. Shah.
No, that's right. So, my lord, I shall not rely on that. That payment certificate shows that, my lord, this entire money has been paid to me, not to, my lord, my joint venture. Just, my lord, 3 things. But if your lordship will kindly, my lord, very quickly, my lord, have a look at 684 once.
Yes.
Well, I made a mistake. I said this is the profit sharing ratio. No, my lord, that's not. Well, this is the joint venture agreement. That's 684. Well, if your lordship will kindly see, my lord, at paragraph 4 at 685. well, the parties have resolved that the distribution of share and responsibilities, well, that is the distribution. So the amount of work done by the lead partner is 51%. The amount of work done by Kalindi is 29%. Amount of work to be done by Tata is 20%. So it's, my lord, not distribution of profits. It is their share, my lord, in the responsibilities and consequently, my lord, entitled to payment. That's number one, my lord. Then, my lord, kindly see 677.
You had shown this on the last occasion.
Yes.
Well, all that I want to show is, my lord, because this confusion was created, and my lord, I was a little, my lord, taken out of, my lord, really by surprise.
Yes.
Now, my lord, kindly see 677, which is the document which we had submitted.
Yes.
Now, my lord, kindly see item number 6. Value of signaling and telecommunication work executed is 68 crores.
Item number 6.
My lord, 677 is, my lord, the document submitted.
679.
No, 677.
677, there is no item number 6.
No, my lord, this is a.
Oh, this is the other matter, probably.
I'm sorry, I was referring to 370.
Exactly.
That is the repetition that your lordship was considering.
I'm sorry, then what was the previous page you cited
That-
just now?
Well, the previous
Then it's,
page
wrong.
was 684. That is, my lord, the joint venture.
677 of this is the other page of the probably the same page of the other.
I see, my lord. Well, I'm
Anyway,
saying
686, it's 684.
was the joint venture agreement or the memorandum of joint venture.
Yes, yes.
Yes. Now, my lord, this, my lord, show it's a sharing of responsibility. So, 51. My lord, the next thing is, my lord, kindly see 677. This
Yes.
is what I had submitted.
677, yes.
Now, my lord, kindly see item number 6 is value of S&T work, 68.46, value of P-way work, 33.6.
Value of the work, yes.
And, my lord, total is 102.
This is exactly the amount.
So, my lord, this is 102 is, my lord, exactly the amount that is paid to me. Total value of, my lord, payment made till date.
Yes,
So, my
Mr. Shah, you made this argument on the last occasion.
lord, just one more.
But made precisely this argument only.
Just one, my lord, indulgence, my lord.
Yes.
My lord, now in view of, my lord, what my learned friend says, kindly just see 6901.
Accepted contract value. Accepted contract.
My lord, only one thing, my lord, 683. My lord, the total accepted contract value is, my lord, much more. My lord, that your lordship will find at the top of the page. 683, my lord, clause number 3.
683.
My lord, the accepted contract value is, my lord, 26 crores, 74, 267 crores. 267 crores,
Mhm.
my lord, 41 lakhs, 11,310. Now, my lord, now your lordship will kindly have a look at, my lord, page 690.
690, yes.
Well, page 690, my lord, is the clarification. This is, my lord, perhaps what I did not show to your lordships. My lord, kindly see the original contract value is 267 crores. So, my lord, this is the value for all of us, GMR, Kalindi, Tata, everyone. 267 crores.
Pink slip for you.
Oh, I'm sorry.
I bought this.
I'm sorry, my lord. Well, just, my lord, I took one moment, only one moment.
Yes.
My lord, 267 total value. Then, my lord, after the contract variation, it was 337 crores. Now, my lord, kindly see item number 5. Value of S&T in final contract value is 87 crores. Now, my lord, this is, my lord, the value mentioned in page 77. Final value of S&T work. Payment made against S&T is 68.46 crores. So, my lord, there is no, my lord, doubt that this is, my lord, the money that is paid to me. And, my lord, I also have now, my lord, a payment certificate from the RVNL, which says that, my lord, this is the money paid to me. Very well.
In any event, I'll forget that. Mr. Mukherjee need not worry on this.
Well, my lord,
I
that is all
definitely forget, I can assure that.
RVNL is respond number 4.
91 is not a big document at all.
RVNL is, my lord, respond 4.
Document which was.
My lord,
issued to the
I am very
President.
surprised that, my lord, today, the railway is, my lord, not making these objections. The party
Yes, my lord,
who
certainly
succeeds
we are
in, my lord,
making the
getting
objection.
Right has accrued in their favor. Naturally, they will.
29% of 267 crores.
They have more at stake than the railways.
29% of 267 crores, which is the total
Yeah.
contract value, is anyway much higher.
677
If total contract value is
So what the original
267,
contract value?
Action.
Why this
my lord, today 267, if that is the total contract value, in that case, my lord, 60, my lord, 29% of that is, my lord, in excess of 60 crores. Well, that is all.
That's the order record.
Complete.
RVNL is respond number
The
4.
arguments sought to be advanced today after conclusion of hearing have already been advanced substantially on the date when the hearing was concluded. So as such, no further order need be passed.
I'm grateful.
My lord, your lordship wants to hear me, my lord, on any point.
No.
My judgment has been dictated also probably, but I'll definitely consider whether I have missed out anything which Mr. Shah pointed out, and you also
I'm
pointed
grateful. my
that
lord.
this is not a bid document.
I'm grateful.
Nothing else. The rest was already pointed out, Mr.
Yes.
Mukherjee.
I am.
Those have been marked by me,
is-
substantially labeled by me.
It is perhaps my anxiety, my lord, of nothing else.
Not your anxiety exactly. Yes.
Grateful. Very grateful. Well, the same in the other matters, so much.
10:30 matter,
10:30.
item 4.
My lord, item 4, my lord, after filing overnight, my lord, now my client is instructed to withdraw.
Learned counsel for the petitioner submits that the petitioner seeks to withdraw the writ petition. Accordingly, WPA 15625 of 2023 is dismissed as withdrawn without any orders to cost. It is made clear that the merits have not been gone into by this court. The written instructions filed today by learned counsel for the petitioner be kept on record in that regard. Grateful. my lord.
Top item, item 5.
I am for the petitioner. This
I'm
that
agreeing
matter
for the
where he has
response.
to serve upon the bank.
My
Not
lord,
serve up in the bank.
Yes, my lord,
Oh, you have, you're for the bank, right? Very well, Mr. Sharma, yes.
The issue was very small.
Hmm.
All the charges which were created were starting from 1977, which appears from the company master data. Now, thereafter, there were certain charges which were created in respect of the 4 tea gardens also.
Huh.
Those 4 tea gardens were hived off or demerged to 4 separate entities which were floated. Now, all those 4 entities, NOC I had shown 179 to 182. Now, thereafter, I write letters to the bank that kindly give me the no due certificate for the other charges, old charges, which was my mistake. What is normal procedure is we have to take steps immediately up to from a period of 1 month. But because here this was the old
What is the
management-
sanction if you don't do that? Mr. Sharma, is there any sanction in law restraining you from doing that? I mean, there's a
No, if
department.
I don't, then I have to pay fine. Suppose they give this document today, and when I upload it with the register of companies, they will take me fine from that day, which I'm willing to pay. But if I do not get the no due certificate, I cannot upload the forms. So long as I'm not uploading, the master data of the register of companies continues to show this dead charges, if I can use.
So
the
what
word.
should be the procedure? They have to give the no due certificate with that, with the undertaking that you will pay the fine.
No, that is
Obvious.
automatic
It's
because now it is all portal.
Oh, right.
The portal will not accept another fine.
Right.
For them, that they are saying that is what my reading is. Obviously, this is very old records, so
My
they
lord.
will not like to, or they may not have the records. I do not know. Now, it will not harm them because bank's money is zero, no claim.
Yes, what do you say?
my lord, their claim are not tallying with our records, and since it is an old record, your lordship, we need 10 days of time.
Yes, I
They-
can wait. There is no issue
Lordship,
because it's only a procedural. Because once they give me,
Right.
I will have to pay the fines to the register of company, which I'm willing to pay.
Learned counsel for the petitioners reiterates the submission of the petitioners, which was recorded in the order dated June 28, 2023. Learned counsel for the bank, on instruction, submits that the bank requires about 10 days time, since the records of the bank are not tallying with those of the petitioners and the records are quite old. In view of the prayer of the bank, let the matter stand adjourned till July 18, 2023, when it will be listed fairly at the top of the list for passing
Only
orders.
one thing in the lordship is may record if they need any
It is made,
assistance, we are also willing
it
to
is made clear that
sit with them.
it is made clear that the petitioner is willing to pay the necessary fines after getting the no objection certificates and
Fines with the ROC.
fines with the ROC, very well.
And in
Fines,
case they have any doubt, we are willing to sit with them.
I'll record that with the ROC. যেটা বললাম, it is further submitted by the petitioners that the petitioners are ready and eager to advance any help if so required by the bank in tracing out the said records.
I'm grateful to your lordship.
What do you mean by help, Mr. Assistance, Mr. Sharma? Speed money.
Lordship,
No,
Speed money, apart from that, what help can you give them?
No, because they are saying they cannot reconcile. Suppose there are
Give
10,
them the details.
no, suppose they are finding, suppose there are 10 charges.
Your people
And-
will go there and find.
No, maybe we'll have to reconcile that all are dead charges, finished. There's nothing, because they might not find, if they find any unpaid charge, obviously they will not issue.
তাহলে ওটা help না
So I
করে
have to
cooperation
correlate.
করো. Cooperation is
Yeah, I have
wider.
to correlate that everything is finished.
And if we require anything, we'll give
Yes.
them a notice. Your
Our
Lordship.
idea is not to take any NOC for a pending charge. That's
Basically, it's a non-issue. I mean, it can be resolved since councillor.
Our fault of the old management.
Right,
is
right, right,
continuing.
right. It's negligence, right?
Lordship.
Deeply obliged.
Next.
Item 6,
Yes, please. What is that?
6, my lord, I appear for the petitioner,
Right.
but kindly, my lord, comes to
Mr. Mondal, you are for the
am
private
for the
respondents.
Private respondent number 7, 8 and 9.
Mr. Bandyopadhyay sought for time on the last one. Yes, what is the matter?
yes, my lord, kindly comes to page 14, my lord. Is the LR a record of rights, my lord? Here I have constructed a residential house, my lord. I am
Yes.
residing there. Now, my lord, kindly comes to page 22, my lord. I have applied and they have raised a quotation, my lord. Annexure P3.
Right.
They have raised a quotation, my lord. Quotation date is 15th of June, 2022.
You have paid the
I
amount?
have paid the amount, my lord. Annexure P4.
Next page, very well, yes.
Lord, in the meantime, my lord, sometimes in the August of 2022, I have been served with a copy of the summon, Mr. Annexure P2, my lord.
Yes.
That is the preemption case we have instituted. No correction with the electricity matter, my lord.
So they can get the electricity.
We are not, we are here unnecessary party, not necessary party, my lord.
This was
Moreover, my
given
lord,
to you by the electricity, the WBCDCL.
No, my lord, I have been made a party, my lord. This opposite party number 1.
So why have you come up to court?
Lord,
What is the cause of action for the deed?
I am not getting the electricity, my lord.
Why are you
My-
not giving the electricity, Mr. Bandyopadhyay?
My representation is Annexure P5.
The money in 2022, my lord, thereafter we have, my lord, inspected, 2 poles are required to be installed. My lord, 1 pole is on the road, there is no problem for that. But one of the second pole, the private respondent number 7 to 9, they are, my lord, seriously objecting.
They are
And
saying
my
they are not objecting.
we are not objecting,
They are
but
not-
one
they are
thing, my
saying-
lord, one thing I am.
My instruction is, after that, my lord, 5 times we have, my lord, approached and, my lord, tried to, my lord, install. And every time the, my lord, petitioner was present in the site, and, my lord, that has been suppressed in the, no mention is there in the.
So what
petition.
happened then?
But even after, my lord, trying our best, my lord, we could not.
So
Because,
why didn't you go for the 6th time?
my lord, now.
Anyway, let us hear Mr. Mondal. What is his objection? Yes, Mr. Mondal.
This writ petition, your lordship will find no allegation against us, my lord. No.
I'll
single
record you have no
sentence.
objection.
Yes, my lord. But one thing, my lord, I am drawing attention.
I'm wanting that one thing
There-
from the
there-
beginning.
There is a road, my lord. If they take electricity connection through this road, common passage, we have no objection.
Hold an inspection with notice to both of them. Find out an alternative common place and
Common passage is
learned
there.
counsel for the petitioner submits that the petitioner has been served, subsequent to having applied for electricity connection and paying the requisite amount, with a copy of a preemption application where the petitioners have been impleaded as parties. Sorry, petitioner has been impleaded as a party. Full stop. It is submitted that the petitioner, despite having complied with all formalities, is not getting electricity connection at his premises. Full stop. Learned counsel for the WBACDCL submits that one of the 2 poles required to be installed for the purpose of giving such electricity to the petitioner is already placed on the common road. Full stop. However, insofar as the second pole is concerned, the WBACDCL is facing objection from the private respondent. Full stop. Next para, learned counsel for the private respondents disputes that the private respondent, respondent or respondents?
Respondents.
Respondents. Respondents are obstructing the supply of electricity to the petitioner in any manner. Full stop. However, it is contended that there is ample space on the public road to install the second pole as well. Full stop. In order to crease out all issues between the parties, the WBACDCL is directed to hold an inspection within a fortnight from date, with prior notice to the petitioner as well as the private respondents, directly or through their learned advocates in this court, indicating the date and time of such inspection. Full stop. Upon holding such inspection, the WBACDCL shall ascertain the feasibility of installing the second pole in a common place, comma, where none of the parties have any objection. Full stop. A report in that regard shall be filed on the next returnable date with service of advance copies thereof on the learned advocates for the petitioner as well as the private respondents. Full stop. The matter shall next be listed on July 17, 2023, fairly at the top of the list. Thank you.
Great.
You are for state
Petition. What's this? Along with him. Yes. Great. Great.
Next.
Item 6,
Yes.
sorry, 7.
Seven.
My application.
Yes.
But this relates to a blacklisting. I start off with one serious disadvantage, which is perhaps an advantage.
Yes.
It is a case of blacklisting after hearing. After hearing, your lordship knows blacklisting, usual grounds and actual justice. Here I've been heard. Now there is a order which is to my advantage. There are not other things here. We are at the ad interim stage, which is also not an advantage to me, perhaps. Now, I tell your lordship what has happened here. What has happened here is there is a tender floated by the respondent authority. I participate. That tender is recalled by them. So, I don't get it. Then there is a second tender. The dispute arises out of that second tender, which was also recalled. There is a third tender where I don't participate. Now, what is the dispute arising out of the second tender? There are certain qualification criteria. I'm not hit by any of those. Then there are some other not so important criteria. One of them is that I have to give a affidavit with certain declarations. Now, those declarations, that declaration is filed by me. The contract conditions, which is what I'll have to show your lordship, say that if the bidder has been disqualified, or rather the contract of the bidder has been disqualified, or rather it has been terminated due to default by the bidder. Please bear in mind the word bidder. And then certain consequences will follow, including forfeiture of the security deposit. Now, in this case, this was a joint venture. So, let's call it A and B. Now, A, in a contract which he had participated in years ago, was also in a joint venture, but with someone else. So, let's call it X. So, A was a 10% bidder there, X was 90%. There, the case was a bid was put in, the bid was withdrawn before acceptance. So, there is no
It was the first tender you referred to, or a different one?
Completely different state. Not this authority at all.
Very well, yes.
So, it was a tender between A and X, where A was 10%.
10%, yes.
That bid was withdrawn before it was accepted. They said, look, you are now refusing to accept it, therefore I blacklist you. That was the situation as far as that was concerned. Now, your lordship knows the judgments of the Supreme Court, a joint venture is seen as a separate entity. The question is whether I had to disclose that as part of another joint venture, I had been blacklisted. This is the question which arises. Fortunately, it's taken care of by a judgment which I'll cite. So, according to me, there was no declaration, number one. Number two, in any case, it could not have led to this consequence. Third, and most important, in this case, what had happened was, they issued a show cause notice to me, but saying they will forfeit my security deposit for this very same crime. Although it was not a pre-qualification condition and the tender was recalled. Now, against that, I came up to the court.
Here also the same thing happened.
Yes, I'm talking about this one.
You refused to work.
No. Here I have not been given it. So, it is arising out of a contract which they recalled. They recalled it. So, there is no consequences arising out of that. But they said, because you have submitted that wrong document, I will forfeit your security deposit.
Wrong document has been submitted here also.
No, here they say it's a wrong document.
No. On the previous occasion, in that AX, in that A and X, that
there was
joint
no
venture,
declaration.
there was no wrong document submission. It was you, since you did not work, you were blacklisted.
Yes.
they take you as a component of that joint venture, not taking you as an identity, I'm one of the components. So they take you individually and they say you are blacklisted for that.
Yes.
On the basis of that blacklisting, nothing is done now.
No, they did
Now
not
it's a
blacklist.
new allegation of you're giving a wrong document.
No, no. On the basis of wrong document, they did not blacklist it. They show caused to
Oh,
forfeit the security.
Oh, very well. Very well.
So, my lord, I went and challenged it.
Hmm.
Now, that writ petition was allowed because although the show cause was for forfeiting the security deposit, they went and blacklisted me.
Acha, very well.
It was also, my lord, allowed on a second ground that they forfeited my security deposit, but they had actually returned it.
Acha, very well.
So they said your cause of action is gone. So I succeed in that. Now, my lord, once I succeed in that, my lord, they give me another show cause notice and they provide me a hearing and they have blacklisted me for 5 years. In respect of a contract which one never came into existence because my lord, there was a first call, like I told your lordship, recalled by them, second call, recalled by them. I don't know what happened in the third call, but I did not participate. So it is with regard to a non-existent contract, really speaking, with regard to a dispute where, Lord, according to my construction of the documents, it can't be a false statement. Even if it is, it can't lead to this consequence.
Mr. Bachat, under the new NIT, the recent NIT,
yes.
Was there any provision of blacklisting in the NIT conditions itself?
Lord, it talks about any other action that they may take in accordance with law. So forfeit security deposit, terminate the bid.
That takes into its ambit this wrong document submission.
Lord, it does not according to me, but Lord, please, Lord, take that with a pinch of salt because Lord, I have got colored because I've looked at the document so many times. I tell your lordship that clearly. Now, Lord, 3 clauses your lordship will have to see, and Lord, hopefully not more than that. Lord, if your lordship would first turn to 7.1. No. Actually, no. Lord, please see clause 7. Qualification requirements. Lord, I'm sorry, page 127. I'm sorry, Lord.
127, yes. 7.1.
Lord, a bidder. So, Lord, these are the qualification requirements. Just one line. A bidder shall have to satisfactorily fulfill the following qualification requirements, i.e. technical criteria and financial criteria, 7.1 and 7.2 specifically mentioned. Now, Lord, they are not disqualifying. They are not saying they have any problems with this. Now, Lord, please comes to 7.8 before I take your lordship to the show cause.
Yes.
Now, Lord, please see 7.8 heading. These are other terms and conditions. They are not qualification. Now, 7.8.3 at page, Lord, 133.
Yes.
In respect of any tender, contract issued by the government or government instrumentality, Lord, A is the one we are concerned with. None of the contracts of the bidder or any member of the bidding group or bidding consortium has been terminated or foreclosed due to their default. So, Lord, 2 parts here. Contract of bidder or member of the bidding group, of which I am a part, have been terminated or foreclosed due to their default. So, it also involves showing termination due to my default. So, Lord, this is one clause. Now, Lord, please see at the end of 7.8.3 at page 134 after A, B, C, D, E, F, G, with respect to the requirements of this clause, the bidder and each member shall submit an affidavit as per format. Now, Lord, after this, Lord, please take 9.1.7 at Lord, page 160.
Yes.
So, Lord, this is what the techno-commercial proposal has to contain and the consequences. The bid security. So, this is to do with forfeiture of bid security now.
Yes.
Because the heading in 9.1 is bid security. The bid security shall be forfeited and appropriated by WBMDT sale as genuine pre-estimate compensation and damages for inter alia time, cost, effort of WBMDT sale without prejudice to any other right or remedy that may be available. So, my lord, without prejudice. And, my lord, what we fall into perhaps is C, 9.1.7 C. If any of the documents submitted by a bidder as part of a bid is found to be not genuine or forged, So, my lord, it must be a document which is not genuine or forged, or any of the claims, confirmation, statements, or declarations that the bidder is found to be incorrect or inconsistent, including declaration under 7.8.3, or in the case of material representation of fact at any point of time through the bid evaluation process. So, my lord, consequence of this is only, my lord, forfeiture of security, not bid money. This is not leading to blacklisting. The condition for that, my lord, your lordship will now, my lord, what they rely on is 9.7, which is at page 163.
Yes.
The bidder, 9.7 point, the bidder, including each member of the bidder group or the consortium, shall, as part of the techno-commercial proposal, submit an affidavit as per the format given in Annexure 9, declaring inter alia that in respect of any tender issued by or contract entered into with WMDTCL, any government or any government instrumentality, but please see A, none of their contracts have been terminated or foreclosed due to their default. Then, my lord, your lordship could see, my lord, right at the bottom, in addition to the above, the bidder, including each member of the bidder group or bidding consortium, shall, as part of the techno-commercial proposal, declare the following as per the format given in Annexure 9. And, my lord, the format is on the next page. Now, we are concerned with C, because this is what they catch me under. But earlier, for the security deposit, they had caught me under 9.1.7. Now, if it is found that at any point of time that our, now, my lord, please mark the words our, documents are not genuine or false or forged. Now, my lord, do I fall within this definition if this itself is the wrong statement? Because in that affidavit, I say that I have not been terminated due to my default. So, if it is found that our documents are not genuine or false or forged, then in that case, our tender will be rejected, earnest money deposited by us will be forfeited, and we will be debarred from participating. So, this is the clause they rely on. Now, my lord, this must obviously refer to other documents. It can't be referring to this affidavit. If at any point it is found that our documents are not genuine.
Yes.
So, my lord, if this affidavit itself, not in this, I do not state that a contract of a joint, of a JV of which I was a party.
Suppose for argument's sake, Mr. Bachchan, this agreement itself is also included.
Let's say so.
Let's say so. Let's take the worst.
Yes, yes.
Then you would be barred, could have been barred under 9.7.1A. That your foreclosure, previous foreclosure was
They have not gone under that. They have not gone under that.
But that is one of the considerations.
And they also, not please see the language, none of their contracts. The joint ventures contracts.
No, not that. Because
A is not specific.
Each member of the bidder group.
No, but A is only none of their contracts.
Yes, it is preceded by 9.7.1 is the bidder, including each member of the bidder group.
Yes.
Oh, you say this refers to the present bidder group.
Yes, not the joint venture. Let's call it not AB joint venture. Not the Supreme Court has interpreted this AB joint venture to be a separate legal entity. And not in conditions like this, I'll show your lordship the judgment, not instead of trying to give forth my view on law. Fortunately, not the juniors have worked hard. They found a judgment covering this. So I'll rely on that. But what it says not is really this. But if there is a JV A over here and a JV B over there, then default on the part of a member of JV B cannot be construed to be a default of either this JV or its member. This is the short technical point I'm on. Other than the fact, not according to me, once they release the earnest money, not the entire cause of action is gone.
You are one of the members of the bidder group.
Yes.
Right?
Yes.
In the present.
Yes.
So if you are one of the members of the bidder group, this applies to you ex facie, the bidder including each member of the bidder group. But the question is whether the previous foreclosure that pertain to you or the joint venture. If you say that the joint venture is a separate entity,
yes.
But that is Mr. Bachchan.
But if I may, just
subtle, but
But it is subtle. I do agree.
Hmm.
But not if your lordship would not once more, if I'll just trouble your lordship with
Absolutely, please. Yes.
reading the clause once more.
Since I'm prima facie against you, that's why all the more.
Yes, not I tell your lordship the difficulty.
yes.
Not this is blacklisting. 5 years of blacklisting.
Yes, that is there.
We work not only for government companies, mining. There is no one else. Not companies' future is completely wiped out. Not as your lordship has seen in these matters.
That is
It is a question of existence.
out of the competition zone. If you are
Not
there,
just
not
that.
there for 5 years, then probably you are out of consideration. again.
Not just that, not the company is finished, wiped out. Not it is civil death. Your lordship has seen, Lord, it's called civil death, blacklisting, which is why, Lord, the judgment say your lordship will have to be very, not construe these clauses very, very, very strictly. So, Lord, if I may just read 9.7.1 again, Lord, this is not talking about blacklisting, Lord. It says I have to give an affidavit. Now, Lord, the bidder, Lord, if I may read 9.7.1, the bidder, including each member of the bidder group or the consortium. So, not each member, I'll take it to be me, shall submit an affidavit. So, not I give a separate affidavit, the other member gives a separate affidavit. As per the format given in Annexure 9, declaring that in respect of any tender issued by or contract entered into with any government instrumentality. Now, let me just leave.
First ones, yes.
Yes. None of their contracts have been terminated or foreclosed due to their default. So none of their contracts. Now, Milord, in the first place, their contract can either mean a contract of this JV, which is participating, or it could mean a contract in which I have participated. But that contract where I have got disqualified is not one where I have participated. That was a separate JV, which is a separate entity.
You were a component there also.
I am a component.
You were one of the
Yes.
members of the bidder.
Correct. But it does not say that I'm part of any consortium which has been. Lord, I'm covered by the first part. Your lordship is right.
Yes, I understand, Mr. Bachot. You say you are not covered by the previous one because the previous one has not been referred to here as member of the bidder group.
Correct. Now, Lord, not just that. Lord, according to me, 9.7.1 is still not right.
So,
up to-
according to you, to cover you in that regarding that, this language of A should have been something like none of their contracts individually or as a part of the joint venture,
Correct.
something like that.
Millard, that's the point. Lord, that's the whole point.
So, since that's not there, we should read it strictly and go in your favor.
Yes.
I mean, whoever is there.
Yes, Lord, that's how Lord, the Gujarat High Court Division Bench has
Right,
also
right, right.
construed a similar clause.
Hmm.
Now, Lord, the point I'm on is, Lord,
Hmm.
if your lordship sees this page up to here, it says nothing about Lord blacklisting.
No, doesn't.
So the consequence is not coming here.
But if
Now-
it is one of the documents, maybe one of the documents referred to in the next page.
Now, Lord, just coming to that. Now, Lord, please see. So it says declare the following. So I have to say these as per a format. So this is a declaration I have to give.
Mhm.
So, Lord, I will assume this becomes a document of the contract. I'll assume
Let
that.
us assume the worst against you.
Yes. If it does, the question is whether a misdeclaration in this document, where I'm making the declaration, will be not followed by a blacklisting. For that, Lord, please see. If it is found at any point of time that our documents are not genuine, I am not the document in which I am saying this is found to be not genuine.
So
Can't
you are
be.
trying to distinguish between the document being genuine and the statements therein being genuine.
Yes, because Lord, please see the language. Documents are not genuine or false or forged. I tell your lordship why.
How can a document be false and genuine at the same time? Genuine refers to the document,
Not genuine. Are not genuine.
not genuine
Yes.
or false. I mean, if it's not genuine, the document is not genuine. But if false has to refer to genuineness, then this will be a repetition unnecessary.
Perhaps.
So genuine and false are two separate words used. If that be so, genuine has to pertain to the document and false has to pertain to the falsity of the statements made there.
Lord, or forged.
Document cannot be false, either forged or not genuine.
Now, Lord, language, Lord, I can't
The-
explain.
this
for-
language has been used by very specialized people, I suppose. Genuine or false have been used separately.
Separate.
So has to be attributed a meaning. So what is the meaning of
Lord,
false?
Lord, before I come to the meaning, may I try and Lord, just explain a different meaning here.
Very well.
Document is not genuine, false, or forged. Now, Lord, I tell your lordship why these clauses are put in. Lord, I do not qualify for a tender because there are certain requirements. Let us say you have a PAN card. I say yes, and I put in a forged document. Lord, the object is to make sure that it is to circumvent a technical requirement, which is why I showed your lordship that Lord, this is not a part of either the technical or the financial.
right.
That is why I showed your lordship that clause at the very
previous
beginning.
ones. Yes.
It is not a qualification criteria.
All right.
This is meant to cover that. I am giving a false
So should
document.
not be visited by blacklisting. I mean, it should be constituted in your favor insofar as is very well, not the suppression of the. But then, Mr. Bachawat, I appreciate your contention fully. You are right on that. But then we have to reconstruct C. I mean, at page 164.
Yes,
I mean, there is no such qualification or shade in the construction of C at page 164 because C is very clear.
Yes.
If it is found at any point of time that our documents are not genuine, this is more on ethics, apparently. Moral turpitude, ethics, these higher things.
Could be.
Not exactly your qualification not being there and you're trying to come in. No, not that. Because they would have an option, Mr. Bachawat, if they knew that you were previously foreclosed, to consider, suppose it's a 50-50 thing or a equal parity thing. Then you could have been excluded probably on that.
May have.
So your documents, all of the documents are relevant here.
No, I say so. But the point is this. Now, Lord, again, Lord, let me just make one last attempt to
No,
just
please
give you a
do.
lordship
Absolutely.
feedback.
Why not? Yes.
No, Lord, it is just this.
Yes.
Lord, today I'm participating in a tender. I have to give an affidavit. Now, I look at this language. I will go by this language. The language does not say that, look, if you are part of a joint venture, you have to disclose details of every joint venture work you have done and point out a default. Because, my lord, these are in law all treated as separate legal entities. Because, my lord, your lordship has seen none of their contracts, none of their contracts and contracts entered into by any entity of which you are a part. Not the law in this, not as I've understood, it seems to
Cite
be
the
clear.
judgments.
Yes, but this is technical. Now, not the other part. The other part is not.
There's something.
Please not see the earlier order which I got. But there they had issued a show cause notice based on exactly this. Same. Now, my lord, I've showed your lordship the difference between forfeiture of the security deposit where the requirements are different. So, my lord, if your lordship would once more just compare, lord, 9.7.1 with 9.1.7. There.
Yes.
There, my lord, it was clearer. 9.1.7c says, if any of the documents submitted as part of the bid is found to be not genuine, forged, or any claim, confirmation, statement, declaration is found to be incorrect. Now here, my lord, it does not say.
Very well. It's on a higher footing.
Correct.
Clearly given. This could have been the language of that.
Correct.
All right.
So, my lord, here the language is very, very clear.
But Mr. Bachawat, I seriously don't want to go into that nitty-gritty. But if you please see the languages, these things catch my eye. I am sorry for that.
Yes.
Now here again in 9.1.7,
yes,
false is not there.
Yes, not there. Not there. I see it.
So it's three things basically: forged, not genuine, or there it is false. Here it is. Any of the claims, confirmation, such and such is incorrect.
Incorrect. So, not
false is greater than incorrect.
Not incorrect is not taking into account a much broader. Not false is different from incorrect. So it is much
go
broader.
into that detail.
Not the net is wider.
A court of law.
Not the net is wider. All I'm not.
Net is wider. Wider than
net
false.
Here is wider, incorrect or inconsistent. See, not how wide the net is. So, not they realize that to forfeit.
In false, there has to be an element of intention. I mean, very difficult.
It would be. It would be. False would. Here, not incorrect, inconsistent. Including, not please see, the declarations. So, not including those declarations. So, now this covers it. For this, he can forfeit my security deposit for a false declaration. He has taken specific care of it.
All right.
But not over here.
For a greater offense, only forfeiture. And now for this, you will be blacklisted. That cannot be the interpretation.
It can't be. It cannot be. It cannot be.
Very well.
Not here. Not if I may put it this way, the eventuality is specifically provided for. A false statement in the affidavit. The consequence is given. There, the consequence of a false statement in the affidavit, my lord. Again, my lord, I know, my lord, I'm taking your lordship's time.
No, not that. Yes.
But
So one other thing is also there, we said, but
Yes.
it's a, I mean, a very technical argument on your behalf.
Yes.
You may say that this is an undertaking given by you that yes, I'll be debarred. That does not give them a right to debar you. Mr. Bachchan, that's a very, I mean, don't want
No,
to
your
be
lordship
subtle,
is right.
but it's on a hair. I mean,
It is not,
so
I don't
it's
think
your
I-
undertaking. You say that yes, I am liable to be debarred, but there cannot be an estoppel if there is no specific clause for debarment. So you may say that also probably.
Lord, that is so.
Mr. Dotto is appearing.
Lord, there is no clause for debar.
You are appearing in this. Then you may say that also.
Why,
If
Lord,
nobody was
yes,
there on the
successfully-
other side, then I wouldn't be so in your favor. I mean, since Mr. Dotto is there, he has a fair chance of controversy.
But I'm
That's
sure
it.
in some matter he has argued that point successfully also.
No, because that is also there. Very well, Mr. But
So,
so no,
Lord-
you have to cite the judgment.
Yes, Lord, before that, can I just show your lordship the previous order passed? Lord? I've told him this. Lord, Lord, this is at page, Lord, 42. Now, I won't trouble your lordship with all of it. I'll just show your lordship the relevant portions. If your lordship would take page 43. Lord, the portion in bold issued a show cause notice why the bid security should not be forfeited for submission of affidavit with false misleading statement. So, Lord, that is the language of 9.7 by 1.7. So, Lord, that was the show cause notice. Then, my lord, your lordship will see. If your lordship then, Lord, turns the page. Lord, at page 44, about 8 lines from the bottom, the case made out was, Lord, Mr. Shah then submitted nowhere in the show cause notice. It was mentioned that the first respondent would take action for debarment. So the notice didn't say so, and that's the ground of challenge. Then, my lord, your lordship can see at page 5, rather page 46.
Got it. Yes. Internal page 5, right?
Yes, my lord. That 6th line from the top. It appears to the court that the bid security had already been returned, which was the ground of the show cause notice. So, my lord, these are the two grounds here.
These are not available to you now, in fact, obviously.
No, my lord. But that cause of action is gone. Once he returns.
That is not there. Yes.
Not that cause of action
These
vanished.
mitigating factors are also not here.
But what I'm saying is there were two grounds there. One is there was no notice that I will blacklist.
True.
The second was the second ground taken was that once you have returned my security deposit, which is also not based on the false statement, because 9.1.7 is that your security deposit will be forfeited for a false statement. Now, having released it, where is the question of forfeiting? Now, Lord, please see the finding at page 47. Inasmuch as the moment the bid security was returned to the first petitioner by the first respondent, the ground in the show cause notice diminished and was no more available to the first respondent to proceed against the petitioner under the said show cause notice.
Mr. Bachchan, there is a distinction here.
Yes.
Forfeiture is they have returned the money. So there is no question of further forfeiture of that. They have already crossed that stage. But blacklisting, if you see from their perspective, blacklisting is a person who is coming up and saying a falsehood. I mean, giving out a falsehood from their perspective. That person should not be given another chance for 5 years. That is the presumption for blacklisting.
Yes.
Now that is on a different footing as forfeiture. Not exactly that always blacklisting is a more serious stigma than forfeiture. Yes, it may be from your viewpoint, but from their viewpoint, forfeiture and blacklisting are two different penalties for different purposes. One is a deterrent. It's a sort of deterrent. The forfeiture is not merely a deterrent. It's a relief you are entitled to in money, actually, in a negative sense or a positive sense. Forfeiture, if there is no forfeiture, you get back the money. But since they have already returned it to you, there is no scope of further forfeiture. That may be one of the considerations. But for debarment, the question is whether you deliberately suppress something. That is a bit different, Mr. But even if they return, then also they may say, I have returned, so I am not entitled to forfeiture. I will not forfeit it. But even then, I won't take you for 5 more years because you have stated falsehood. That may be
I won't press this point
because this is not on ethics at all. This is merely on the principle of blacklisting.
I won't press that point.
Yes,
In fact, not the order says this.
Yes.
At the end,
Yes.
it is however made clear the court has not gone into the merits against the
That is
first
also
petition,
right.
and this order will not preclude. So,
Right.
so this will not preclude is there. Now, what I'm making out of it is not his cause of action has really vanished. His cause of action for forfeiture was, look, you have made a false statement in an affidavit. That has vanished, but not, I don't need to go into this. Now, not first on bidder. I've showed your lordship not what bidder is. There is also not a definition under the contract, which I forgot to show your lordship,
That
which is at page 73.
Right.
This is the last thing I show your lordship from here. Sure.
Yes, Mr. Bidder.
Now, my lord, bidder shall be either a single corporate entity incorporated under the Companies Act or a consortium, which shall be, each of which shall be incorporated, who, if awarded the project, undertake to form a SPV under the applicable laws. So now, my lord, before I cite the judgment, if I may just not again once just formulate the point. Not first tender over here, recalled, second tender over here, for which I am accused of the not incorrect or forged documents, recalled. So there can't be any damage to him. It's a question of ethics, like your lordship says. Third tender, I don't participate in. Now, now, my lord, in relation to that second tender,
yes.
Mr.
Bachot, second tender, what was the reason for that?
They recalled it. They recalled that tender.
Very well.
But I am being penalized for that tender which has been recalled by them.
But even then, you did not. You withdrew.
No. No, they cancelled that tender.
So why was the forfeiture there?
That's not its strange. But that tender was abandoned. They abandoned the first tender for this project. They recalled second tender, abandoned. This is the third tender which was floated where I did not participate. My blacklisting arises out of the second tender.
Mr. Bachot, only one thing, the foreclosure on which you are being held to be guilty of suppression, that foreclosure was set aside by Justice Rai. That very foreclosure.
Yes. That's to do with the second tender.
So that is your worst suppression. I mean, if I may say so. Here.
No. But that suppression relates to a contract with a third party. I told you a lot.
I'm sorry. Yes.
Third party and a different joint venture.
Yes. So these do not come in actually, in a sense.
But what I'm saying is, look, he could not have suffered any loss. That's for sure, because those tenders never fructified. Now, but this is the factual background. The second part, which I'm not stressing on, here it is tender A, joint venture AB.
Yes.
Was part of another joint venture, called AC in some other tender. Then I laid stress on the word, therefore the bidders or people they were involved with or any member of the consortium is not in common. And on a clear reading of these words, mention of that other contract was not required. Then, my lord, I've showed your lordship that 9.1.7 is much wider. The language is very, very clear. On the contrary, 9.7.1 will have two holes, at least. The first one being document, the word document. That affidavit itself can't be the document he's talking about. Two, not genuine, forged, etc. Can't cover this.
Right. So these are your base points basically. One is joint venture, one member. Previously it was a joint venture, so that cannot be taken into account. And the second is that this is for a greater offense in a sense.
Yes.
You're restricted to foreclosure. But for a lesser offense, you cannot be. I mean, it's the other way around actually. Your offense is lesser because you are not doing something false. There's a scope of ambiguity. Yes. So it's not false actually. Very well. But forfeiture is for a much lesser offense.
Correct.
If you omit anything.
Correct. Now, which leads to one legal proposition here. These have to be very strictly construed because of the civil and drastic consequences which follow. And if required, construed in favor of the person being blacklisted.
Right. Very.
And if there's any scope for ambiguity, then Lord, it has to be in my favor. And Lord, the last thing is a conclusion of fact which I ask your Lordship to draw. Lord, he issued a show cause notice for forfeiting. I challenged it. Then he discovers, look, I can't forfeit because I've already returned the money. So, Lord, this is a punitive step for having taken him to court. He could not get what he wanted. So, Lord, please see, he blacklisted me without giving me a notice. He gave a notice saying, I will forfeit your security
Is the
deposit.
forfeiture failed, now they're taking this punitive.
No, forfeiture
took them to
failed.
court.
No, Lord, forfeiture failed. So he blacklisted first. That's what was set aside by the court without having given the notice.
Right.
So, Lord, this was all pre-decided. He knew I did not fall within 9.7.1. So he invoked 9.1.7 to blacklist. Lord, that's wider.
Very well. Get your point.
Now, Lord, in this background, please have a judgment of the Gujarat division bench. Achi copy. Other side card diya dono, please. Wait.
Yes.
Lord, if your Lordship would not come to first 4.1.2. Lord, I won't trouble your Lordship with too much of it, hopefully. Lord, I'm not referring to the usual judgments on blacklisting. Your Lordship knows the principles, but the facts are very close. Lord, that's why. 4.1.2, learned advocate further submitted that in different clauses of the tender document, the word bidder was used and it meant individual bidder distinguished from any other person. Then, Lord, clauses are referred to. I won't trouble your Lordship. Please comes to para 5.1.
Yes. Yes.
Clause 1.1, 13 provided for disqualifying the bidders. To specify in what circumstances the bidder shall be disqualified, reads as under. The bidder shall be disqualified. Now let's see how detailed it is. If A, the bidder had made a misleading or false representation in the forms, statements, attachments submitted in proof of qualification requirements. But it's clear. Someone will know, look, you can't give it for the purpose of qualifying. Then Lord B, record of poor performance, etc. Then Lord, including litigation history. Then Lord C, the bidder has been blacklisted by any government, non-government, private agencies, organizations, undertakings, etc. Then the bidder should provide accurate information on litigation and or arbitration resulting from contract completed or under execution by him over the last 5 years. A consistent history of arbitration, judgments, etc. or any partner of the joint venture. Now let's see, any partner of the joint venture may result in disqualification for the proposed work. Then Lord, 5.1 sets out further detailed requirements that they have. Please come to 5.2. Now the principle is being laid down. It was the correct proposition canvassed on behalf of the petitioner that the conditions in the tender document should be said to be penal in nature, has to be construed and applied strictly. It refers to the cartel judgment, which I'm sure your Lordship is aware of. I won't refer to that. Please turn the page. Principle, third line from the top. I'll read from the middle of the sentence to keep it short. Principle was stated that when the tender bid contains an eligibility criteria, the corresponding obligation to satisfy the criteria arises, however, when the tender document does not provide specifically about certain disclosure. The authorities cannot scrutinize the tender document by what is not provided for. Not as in our case, not like I said, like your Lordship pointed out, not 9.7.1a should have had a few more words. 5.3, the word bidder in relation to and as applied to in the instant tender document would mean the individual petitioner itself as the tenderer. Strictly speaking, the petitioner was not the tenderer in the Rajasthan project. It could be said it was not the petitioner entity who was debarred and blacklisted there. When the information in the instant tender was furnished, about the bidder, the non-mention on the part of the petitioner about the joint venture in Rajasthan having been treated as debarred could not be said to be fatal for the petitioner to get its bid considered, nor could it be said to be a suppression or prejudicially affect the petitioner. Then, my lord, in Gammon, India, the Supreme Court highlighted the concept of joint venture, and this.
Bachat, once again, in that AX, that thing.
Yes.
Now, were you debarred or foreclosed only?
No, I'll tell you, Lordship. They have not two partners.
Yes.
I was 10% partner. The other was
the joint
90%.
venture was debarred or foreclosed?
Lord, it was debarred. The language used is debarred. Although in our case, I'll tell you, Lordship, what happened.
Yes.
The documents are here. We had withdrawn the offer before it was accepted. They said that we have sent it to you, but nothing could be shown. And therefore, we treat the contract as concluded and treat yours refusal to perform. That is the.
Very good. Let us come back to Gammon.
Not 5 point. Yes, not. It was stated that a joint venture is a legal entity in the nature of a partnership of the constituent companies. It was held that the appellant before the court, Messrs. Gammon Atlanta joint venture, a joint venture could be treated as a legal entity with the characteristic of a partnership in which Gammon was one of the constituents. It was held by the Supreme Court that it was inevitable conclusion that the import of concrete batching plant by Gammon India cannot be considered to be import by Gammon India Atlanta JV, which was a separate person. Thus, the position of law is that the joint venture is a legal entity in the nature of partnership of constituent companies and has its own distinct character and existence in the eyes of law. In yet another decision, this is the one which we were more familiar with, not in the days perhaps when your lordship was in the profession, New Horizons. The Supreme Court explained the expression joint venture and the concept thereof. In other words, the joint venture was a separate legal entity. And then, Lord, it was that entity, separate and distinct from the petitioner herein, which was debarred in respect of the Rajasthan project. Then, Lord, your lordship could also briefly, go through 5.6 and 5.7. The ground that there was suppression of pending litigation was also without substance. There was arbitration proceedings, etc. Please see just the last line, Lord. Could not be said to be violation of the essential conditions of the tender document. Then 5.7, Lord, if your lordship would again flick through that briefly, about 4 lines from the top. What was required was the bidder's credentials, the petitioner itself for the purpose of the instant tender. The non-disclosure did not become a corrupt practice or fraudulent practice. These terms for the purpose of tender were defined by connotation. These ingredients are not fulfilled, etc. Then 5.8. The terms and conditions of the tender document and the question of violation has to be strictly construed. And then it went ahead, and I won't trouble your lordship with the rest. But now, in conclusion, I would want to add something, just not a sympathy factor, nothing more, not a technical point, but not a practical reality. Your lordship has seen, the clause is blacklisted for 5 years. Now, it is not just a blacklisting by him, because every government entity will also carry a similar thing that if you have been blacklisted by anyone else, that also disqualifies you. So it is not that I am losing out on work in one tender, but effectively my life is put to an end. It is civil death. Now, my lord, in the facts of this stage, my lord, I say, Lord, that these are not documents your lordship knows, drafted by them. Lord, if someone is to suffer for lack of clarity, Lord, it should not be me, particularly when the consequences are so drastic and it leads to 5 years. Lord, no company can survive for 5 years. Lord, those are my submissions.
No, nothing.
Lord, I have very persuasive and hardworking juniors. Lord, so Lord, one has to respect their wishes.
Definitely. Mr. Bachat, no doubt on that. Definitely no doubt on that.
Lord, in the background of what has been submitted,
yes.
First, kindly have a look to Lord, the debarment order by WCL.
Lord, I'm very sorry, Lord. Lord, I forgot to add one thing, Lord, and that perhaps is something which your lordship will not once need to open the brief. I'm sorry, Lord, but I shouldn't be doing it. But I got so deep into this that I forgot not what is perhaps one of the main points. Show cause notice given. There's a reply. In the reply, I've taken all these points which I've taken before your lordship. Now, like I said, hearing and there's a decision. Not your lordship will not just flick through the decision just for one moment to show, not only to show this that not dealt with at all. It is a repetition of the show cause notice. So, Lord, for that, Lord, if your lordship would first take the show cause notice, which is at page 36. The order is a verbatim, almost verbatim reproduction of that. Not page 36.
Show cause.
They quote the same clauses, etc. Lord, it's a longish thing. Then, Lord, please see the impugned order and compare it. Not
What is the page number of the?
not the next page. I'm very sorry. Not page 38.
Achha.
Lord, up to Lord, your lordship will see at page 39. He has set out the show cause notice verbatim almost. Up to the last para. Lord, your lordship is at page 38. This is the order, blacklisting order. So the first whole page and the second whole page is setting out the show cause notice. Then, Lord, his reasons follow. Lord, please see, Lord, how he construes it. Lord, his finding at page 40. And whereas in your letter dated so and so, so now he is quoting my reply. You have denied, etc., etc. Now, Lord, he sets it out, but he doesn't not deal with it. None of the contracts of the bidder or the bidding group have been terminated or foreclosed due to your default quoted. While denying the allegation, you pointed out that in the subject NIT, the bidder was Deco MV and no contract of Deco MV JV was terminated or foreclosed. So this is the point, Lord, which I have taken. You have also referred to the contract, etc. So, Lord, he is now, Lord, referring to and setting out my reply. And then, Lord, and whereas after submission of the written reply, and then, Lord, the next para is again, whereas undersigned has considered the reply. Then, Lord, he starts at the last para. The other plea that you have taken in the reply, that Deco had only 10% share invited by the contract, which was of the contract was not terminated, also does not hold good, as in the tender invited by so-and-so, there was no mention about the percentage. So this is the not small thread on which he's gone. On the contrary, it was mentioned in 7.8.3 of the RFP that none of the contracts of the bidder or any member of the bidding or bidding consortium have been terminated or foreclosed due to their fault. Therefore, punishment order of WCL was binding on Deco being one of the JV. Therefore, it may be concluded that on the day of submission of the affidavit, although you were well aware that due to having default on the part of the bidder, the contract had to terminate by WCL. In spite of that, you submitted an affidavit contending none of our contracts have been terminated. Not where is the finding, not which is required for 9.7.1c. Not there. It is a mechanical reproduction of the show cause notice and the reply, and then he says 10% will not do. So there are no reasons whatsoever. That reasons is what was necessary.
They said they will not.
No, this is the earlier rate.
Yes.
So what's the bearing of that?
Previous allegations.
Let me have a sir. Yes.
I'm sorry, Murad.
No, sir.
I had to
Yes.
jump up once.
Yes, Mr. Dutt.
But first is, my lord, the debarment order by WCL. It starts at page 52. And my lord, the relevant portion, my lords will find at page 55, the last paragraph.
Yes.
Please take the last paragraph.
Right.
In view of the above, these are being done, then please take II at the extreme bottom.
Yes.
You, that is the JV, jointly and severally, along with the directors, partners of Messrs. Dilip Bilcon, Bhopal, and Messrs. Dhansar Engineering Company Limited, which is the petitioner here, are individually, jointly, and severally debarred from participation in future tender of WCL for a period of etc.
This was the AX, that debarment.
Yes. So therefore, my lord, the arguments on the joint venture being a legal entity, my lord, no quarrel with the proposition, but in view of the fact over here that both the joint venture and its constituents being debarred, my lord, in my very respectful submission, my lord, that argument, my lord, do not merit, my lord, consideration by this court. Number one. Number two, my lord, the clauses have been placed. Please take, my lord, page 164, the part of the affidavit. I'm sorry, 163.
163, yes.
First is at the top, the bidder, including each member of the bidding group or the bidding consortium, shall, as a part of the techno-commercial proposal, submit an affidavit as per the format in Annexure 9, declaring inter alia that in respect of the tender issued or contract entered into with so and so any government or any governmental instrumentality, none of their contracts have been terminated or foreclosed due to their default. The Bombay High Court, where they had approached, has returned a finding on this. I'll rely on that. Then B is, as on the RPF publication date, the bidder or any member of the bidding group or the bidding consortium is not blacklisted, banned, delisted, suspended from business or under purchase holiday in the said tender. So bidder or any member of the bidding group.
They were still continuing to be blacklisted as per that previous.
No, I think 1 year. 1 year. That's
Probably.
over. That's over. Now please take, the bottom of that page. In addition to the above, the bidder, including any member of the bidder group or the bidding consortium, shall, as part of the techno-commercial proposal, declare the following as per the format in Annexure 9. Then, my lord, your lordships had, my lord, considered, my lord, A, B, C. Now, my lord, emphasis on the word false, whether it would relate to a document or information. Some clarity you should get from the next clause, that is D. Decision whether the documents submitted are genuine and authentic will be taken by the WBMDTCL based on verification and will be final and binding on the bidder. Therefore, genuine or forged relates to document, and falsity would relate to information.
Right. Yes.
Now, my lord, kindly take, my lord, the impugned order of debarment, which your lordships would find at page 38. Now, may I place, my lord, from page 40?
Yes.
And whereas the first recital over there, with a letter dated 2nd March, you submitted your reply to the show cause notice. In your said reply, you have denied the allegation contained in the show cause to the effect that none of the contracts of the bidder or any member of the bidding group or the bidding consortium has been terminated or foreclosed due to their default. Now, this is directly contrary to page 55, which I have shown. While denying the allegation, you pointed out the fact that in the subject NIT, the bidder so-and-so and no contract of the JV was terminated or foreclosed due to its default. You have also referred to the contract which was terminated by WCL was participated by the JV, where DECO was only 10% member in the JV. You have also relied upon the fact that DECO in its individual capacity did not participate in the tender. You have also referred about filing SLP before the Honorable Supreme Court of India, challenging the solemn order of the Bombay High Court, as one of the defense towards submission of the affidavit was false incorrect statement on oath. You have also relied upon the disclosure pursuant to the earlier tender invited by WBMD TCL in respect of the same coal block in the year 2019. Apart from that, you have also referred facts regarding non-returning of EMD, 5 crore, etc. Then, my lord, hearing was given. Now, please take, my lord, the next paragraph. And whereas the undersigned has considered the reply submitted by you and oral submissions made on so-and-so. After careful consideration of the written reply and oral submission, it appears to me that while submitting the affidavit in terms of clause 7.8.3 and annexure 9 to the RPF, inter alia contending none of our contracts have been terminated or foreclosed due to our default through Mr. Sani Kumar Vishwakarma, the order of the Bombay High Court was subsisting, wherein the Honorable High Court recorded that there was default of the bidder for which the contract had to be terminated. It would be pertinent to mention here that merely filing SLP, etc. Now, we're pausing here for a moment. We'll kindly have a look to the Bombay High Court order.
Bombay High Court order was regarding the previous one.
WCL tender. Now, please take the 9th page of the order,
Yes,
para 19.
para 19, right.
Condition number 4 of the tender conditions, para 19. Bombay High Court.
Watch.
Condition number 4 of the tender conditions is in respect of performance security. Performance security of 5% of the value of etc. within 8 so and so. Failure of the successful bidder to comply with the requirement of performance security deposit was sufficient ground for cancellation of the award of the work and forfeiture of bid security. The respondent reserved the right to debar the defaulting bidder from participating in future bids for a minimum of 12 months. Since the respondent petition number 3 has failed to comply with condition number 4 of the tender document, the respondent was justified in passing the impugned order. Before passing the impugned order, principles of natural justice were followed, and hence no fault was found with the impugned order, as the same is passed within the 4 corners of the terms and conditions of the tender. Then, my lord, the rest is not required for me. Therefore, my lord, the Bombay High Court had written this finding that there was a failure to comply with a condition, paragraph number 20. In the background of this, my lord, please come back to page 40. The portion which I have just read, the last 4 lines of that paragraph, wherein the Honorable Court recorded that there was default of the bidder for which the contract had to terminate by WCL. So this is a consideration by me taking note of Bombay High Court's order that there was a default on the part of the JV. The next paragraph, the other plea that you have taken in your reply that DECO had only 10% share in so-and-so in the tender invited by so-and-so, or the contract of JV was not terminated, also does not hold good, as in the tender invited by so-and-so, there was no mention of about percentage of shareholding in the JV company. On the contrary, it was mentioned in 7.8.3a that none of the contracts of the bidder or any member of the bidding group or the bidding consortium has been terminated or foreclosed due to their fault. Therefore, the punishment of WCL was binding upon DECO, being one of the JV members of bidding consortium of so-and-so. Therefore, it may be concluded that on the day on submission of affidavit in terms of 7.8.3 and annexure 9, although you were well aware that due to having fault on the part of the bidder, the contract had to terminate by WCL. In spite of that, you submitted the affidavit inter alia contending none of the contracts have been terminated or foreclosed due to our default causing wrongful gain to yourself. So-and-so to debar. Therefore, my lord, first is, my lord, this impugned order, my lord, cannot be said to be an order or a product of non-application of mine, number 1. Number 2, my lord, in the background of whatever has been submitted both by Mr. Bachawat and me, my lord, please consider, my lord, whether, my lord, the decision or the conclusion is a plausible one or not, or a possible one or not. I take the case to its extreme so far as I am concerned. Number 1 is irrespective of your percentage of participation in the other joint venture, the petitioner has been debarred, punished. Based on that, my lord, 9.7.1a at page 163, my lord, in my very respectful submission, squarely applies. Number two, my lord, the falsity at page 164 would refer to an information rather than a document. But a document can be genuine, can be forged, can be fabricated.
Mr. Dotto, if there is no provision for debarment in the contract, suppose, then also you can debar under
Yes.
certain circumstances by giving a hearing, which you have done in the present case. So even in this present case, I mean, could you go beyond the clauses and debar? But here you have referred to certain clauses and debarred.
Yes.
So you have to stick to those.
Right.
What about the other aspect of the matter? This the Gujarat High Court principle. Yes.
But Gujarat High Court, madam, in my very respectful submission, is on a different footing. Why I say so? Please have a look to the portions which my learned friend has placed before my lord. First, the clause over there, 5.1.
Yes, 5.1.
The bidder shall be disqualified if the bidder has made a misleading or false representation. Then C, the bidder has been blacklisted. But our expressions are wider. Now, the Gujarat High Court construed this clause in the background of the submission, which is at paragraph 4.1.2 of the judgment, Gujarat judgment. Please take paragraph 4.1.2. The clause, the submission. Learned advocate further submitted that in different clauses of the tender document, the word bidder was used and it meant individual bidder distinguished from any other person. Learned advocate for the petitioner referred to clauses so and so, Millard, for the distinction. Now, please have a look to Millard. Paragraph 5.3.
Yes.
The word bidder in relation to and has applied to in the instant tender document would mean the individual petitioner itself as a tenderer. Strictly speaking, the petitioner was not tenderer in the Rajasthan project. It could be said that it was not the petitioner entity who was debarred and blacklisted there. But I pause here for a moment. In our case, Miller, the petitioner was individually blacklisted along with the JV. Miller, factual distinction as well as Miller, so far as the clause is concerned, different. May I proceed? It could be said that it was not the petitioner entity who was debarred and blacklisted there. When the information in the instant tender was to be furnished about the bidder, the non-mention on the part of the petitioner about the joint venture bidder in Rajasthan having been treated as debarred could not be said to be fatal for the petitioner to get its bid considered, nor it could be said to be a suppression to prejudicially affect the petitioner. Then Millard Gammon, etc. is considered, Millard, where it says that the JV is a separate legal entity. Millard, there is no quarrel on that issue. The applicability of this judgment, Millard, in the facts of our case and in the background of the clause in our NIT, Millard, in my very respectful submission, is inapplicable. Please have a relook to Millard, page 160. 3 once more.
3, yes.
The bidder, comma, including each member of the bidder group or of the bidding consortium shall as part of so and so submit such and such.
So each member is a keyword here. But again in A, you say none of their contracts have been terminated or foreclosed due to their default.
Yes.
And Mr. Bachchat says that the individual member here, the petitioner, that the petitioner's contract was not terminated previously, but it was a joint venture, which is an individual identity. So here in A, you do not say that none of their or their individual components or members' contracts, something like that is absent here. So how do you reconcile that? You rely on page 55 probably, that
Yes.
you say that individually also they were,
yes.
that was clarified in that order.
Yes. Therefore, my lord, over here, bidder, each member has to be read with A, none of their contracts. So this would include none of your contract or the bidder's contract.
But it was a joint ventures contract.
Yes.
That is what there.
Yes, yes, yes. And my lord, at the bottom of page 163, in addition to the above,
Each member, yes.
the bidder, including each member of the bidder group or the bidding consortium, shall be part of the technical commercial project declared the following in such and such. Therefore, my lord,
Their undertaking per se is not is nothing. I mean, that does not entail you to devour. And even if they give an undertaking, that is like saying that yes, if I commit theft, I'll be charged of theft. But
Yes.
you have to satisfy all the same that they have committed a theft under the law.
yes,
I mean, debarment individually, you have to prove that there is an occasion of debarment. Mere this undertaking won't do.
yes. But otherwise also, my lord, your lordships know, my lord, debarment, blacklisting conceptually is a right not to do business with you in future.
Yes.
It is the reverse or corollary to Article 19(1)(g).
Yes, in a sense. Yes, right.
I have a right to do business with you. Similarly, I have a right not to do business with
But if you're a public authority, Mr.
Yes.
Datta, then
you. Yes. That's why, my lord, your lordship kindly considers, my lord, taking an overview of the entire matter, my lord, whether, my lord, the decision is arbitrary on the face of it.
that argument is always there. You have already made that.
Yes.
If it's plausible, then it can.
Yes, yes.
Fair. Yes.
But perhaps not in the case of blacklisting, a plausible view, not test can't be applied. But not leaving that apart, not as I see the two arguments which I need to deal with.
Could I take your lordship's leave?
Oh, yes, yes.
No. এবার দেখো expertise কি সব করছি দেখো। Now, my learned friend's distinction in the argument is perhaps not based on the correct fact. Not just go back to the Gujarat judgment, not where in 5.1.
5.1.
Your lordship sees 13. The bidder shall be disqualified if. Not now he says individual bidder. The bidder. Now, my lord, please see the last line. One of the requirements is consistent history of arbitration award judgments against the applicant or any partner of the joint venture. And this was the basis. This is the basis of that construction. Now, my lord, there was a specific requirement there which is looked at and not construed to the contrary. Now, my lord, I think, my lord, we are missing the woods from the trees. My learned friend is, my lord, confusing between two separate, my lord, different things over here. One is whether a contract of mine has been terminated, which is one set of facts, which is what the contract and the show cause notice talks about. The other is not what he relies on. Not please just compare not page 40 once, page 40 with 55. He compared these two. There's a not very fine distinction here, but it's there. Not that quotation which he reads from second last para. None of our contracts have been terminated or foreclosed due to our default. Not just keep this in mind. This is the charge I'm facing, not that I have been blacklisted. Now, in this case, my lord, if it means joint venture, none of our contracts have been terminated is absolutely true. This is nothing to do with, my lord, the components. Now, as far as that is concerned, my lord, it would not be a false statement. It would have been a false statement if I said none of the joint venture partners or their partners have been blacklisted. But that is not what I'm being caught for. Because page 55, not please come to page 55.
Blacklisting was jointly and severally.
Correct.
But here,
But it did not mean, Lord, that the individual's contract has been terminated. This is the Lord, point which my learned friend is taking advantage of. But this is the distinction. This is the distinction. And my learned friend can't say it's a possible view. But when the consequences are as drastic as this.
yes, not merely stigma, but your business goes.
Business is shut down. It's not that he has the right to choose. I will not work with him. But he's ensuring I can't work with anyone else. So this distinction my learned friend has perhaps not skimmed over. And if this is that distinction in language. Here, my lord, simply this our will not do. And as I've showed you, lordship, my learned friend did not try to meet it. There's no reasons. Even that para which he showed, page 40, my lord, please see.
That is the only reason, I mean.
There's
40,
no reason
41,
here.
yes. Very nice.
Those are my things.
Hearing concluded, arguments reserved. I'm not inviting affidavits in this matter.
No, not required.
Actor line ad করে দিন, in view of the arguments being made entirely on the interpretation of the clauses of the documents annexed, as well as questions of law, comma, no affidavits are invited, full stop. Accordingly, it is deemed that none of the allegations made by any of the parties are admitted by the other. Full stop. Judgment is reserved in the matter. I'll come back in 10 minutes for the next matter.
This is the tender
Lord, if you are not, I asked my learned friend to stay back only for this.
Yes.
Lord, there is a tender of NTPC, which is not the last date of which is tomorrow. Now, because of this, I stand disqualified. If your lordship could grant me Lord, a few days protection, Lord, that this will not prevent me from participating in other tenders. Not if it commends to your lordship. I spoke to my learned. No difficulty.
আগের থেকে আপনি একটা অর্ডার অ্যাড করে নিন। The petitioner, comma, during the pendency, the petitioner, comma, till disposal of the present writ petition, comma, shall be entitled to participate in any other tender as if there was no blacklisting order, comma, subject to the outcome of the present writ petition. Full stop, it is made clear that nothing in this observation shall confer any special right or equity in favor of the petitioner in the subsequent tender process.
Obliged.
Thanks.
Deeply obliged.
Thank you, sir.
New motion, item 8.
Item number 8. Programs funded surgery for the petitioner also came to the court but not felt feeling well and left for praying for one day accommodation.
Tomorrow, on the prayer of the petitioner, the matter is adjourned for the day.
I am for the state and appellate authority in this matter.
Yes, yes, please give in.
Item 9.
When should I take it up? On the prayer of the petitioner, the matter is adjourned for the week. Thank you.
Item 10.
Item number 10 and 11, I have for the petitioner. But allow me for option of the evidence of service. Not complicated.
Come back tomorrow.
I appear for the respondents, my lord.
You are appearing for the respondent.
Yes,
Should I take up the matter?
Kumar Bhattacharya appearing for the respondent.
Only
Item
thing, my
number
lord.
10.
Although it's a very short matter, I have
Huh.
received this brief at 11. Although it's a very short matter.
11?
At 11 a.m., my lord.
Today morning.
Just today morning, this morning.
I can't get you, yes?
I have
At
received
11 a.m. today?
Yes.
Acha, should I take it up tomorrow? I'll take it up tomorrow, affirm your affidavit of service and
Clerk is not, put on,
when should I take it up? Tell me.
give me time, my lord. Otherwise I cannot complete the evidence.
I'll take it up tomorrow.
কালকে নেবেন কালকে নেবেন আপনি পারবেন
On the prayer of learned counsel for the parties, the matter is adjourned for the day. Please come prepared tomorrow.
11.
None appears for the parties next monthly list.
10 and 11 both are going on.
Oh, I'm sorry. 11 is same. On the prayer of petition, আগেরটা যা হলো। That 11 দেখছো কেন? 10, 11 তো একসঙ্গে বলুন। দেখো পট।
12.
দেবো আপনারই তো
12, may I please, Lord?
Yes.
For
I
the
appear for that
petitioner,
state.
this is my affidavit of service. One of the respondents refused to accept the.
Refuse to accept.
Refused to accept.
Yes. What is the matter?
I made them, his name has been given as a party respondent.
Which one is
Because
it?
in the portal, the name is showing. No, nothing, no post has been showing, that's why.
What is the
Well,
matter?
what happened in this peculiar situation? The state government floated the scheme for the.
Please take the microphone a bit closer to you, Mr. Kundu.
My lord, the state government floated a scheme for the student credit card.
Right.
I passed the higher secondary examination. I admitted Chandigarh University.
Hmm.
Thereafter, the statement of account has been sent by the Chandigarh University. I made an application, and all applications should be made by the through an portal.
Hmm.
I applied and registered my name in the portal. And when I submitted my Aadhaar number, the portal shows that my application has been duly registered and ID and password should be sent to the some phone numbers.
Hmm.
And the phone number is not clearly first 2 digit and last 2 digit was showing. My lord, thereafter, I have nothing, the ID and password has not been sent to my phone number because the phone number is not matching. Thereafter, I again log in the portal. The portal shows already Aadhaar card has been registered. I made then and there I made an email to the authority higher education department authority concerned. They replied me to asking for some documents that this thing has been happened. My Aadhaar card and the portal showing the pop-up message. I have sent it attaching the with my email. They replied and said that it will take some time. The authority concerned will reply you. Till date, no reply has been given. My semester is forthcoming. July 1st.
What exactly do you want them to do?
My application should be considered, and
Yes,
if
yes.
I eligible for getting that loan, I may be provided.
But previously he applied with a different mobile number with different mail ID.
So how soon can you process it?
It's Nashikali direct 2 weeks.
2 weeks. That will be too long, I suppose.
When the
Because
next date?
First July, my session has been started, and physical class should be will be started on August 1st.
Then now we are in
Well,
July.
within July,
it's all
they
right.
should-
First July is almost 2 weeks time. Right.
the grievance of the petitioner is that she has applied for a student credit card, student card for student credit card, comma, for the purpose of getting student loan, full stop. However, comma, the same was initially not processed due to certain technical errors, full stop. Upon such errors having been rectified in the meantime, comma, the petitioner has applied by giving a representation to the respondent authorities to consider her application expeditiously. Full stop. Next para. Learned counsel appearing for the state, comma, in his usual fairness, comma, submits that there is no difficulty on the part of the respondents at present to process the said application of the petitioner. Full stop. Accordingly, WPA 14615 of 2023 is disposed of by directing the respondent authorities to take a decision on the application of the petitioner for obtaining student credit card as expeditiously as possible, comma, preferably positively within July 18, 2023, full stop. Immediately upon such decision being taken, comma, if the petitioner is considered to be entitled to the same, comma, the due consequential procedure shall be taken up by the respondents expeditiously. No address to cause urgency.
Grateful.
Grateful to lodge.
প্রথমে একটা দিয়ে দেবেন ওই এফিডেভিট অফ সার্ভিস ফাইল টু ডেভিকেট
13.
In this matter, Mr.
13.
Mahmoud Al Hassan is appearing for the petitioner. He is praying for not today, Madam.
Next month,
I am for the board of Waqf.
next monthly list then. Adjournment is sought by the petitioner. Let the matter stand adjourned till the next monthly list.
Matter is not maintainable at all.
Monthly list of August. Not maintainable. Why? Let him come. Yes.
It is a Waqf matter. Yes.
Oh, acha, acha.
Initially, he has to come.
Let
Go
it be dismissed before the petitioner, the advocate, actual advocate.
83, section 83, your lordship knows. Grateful lordship.
14.
Yes, please. What is the matter?
The affidavit of service, my lord.
Good service has been effected on all.
My lord.
All.
I appear on behalf of WBHCTC, I raise the point of maintainability.
Acha, very well. Why not maintainable?
No, my lord, this is a money claim.
Acha, yes. Yes.
My
what
lord,
is that?
there was a tender, notice inviting tender, my lord, it is at page 11. My lord, it was for extension of control room building and renovation work. I did that work, work orders were issued, revised work orders were issued, and then, my lord, completion certificate at page 17. Completion certificate was issued. I was made a payment. It was a tender for 1 crore 42 lakhs something amount, and only 14 lakh 48,000 remained. I issued them notices on 19th March 2019, then 8th July 2019, then 7th August 2019. Lastly, the notice was issued to them on 14/11/2022. And I also paid the GST amounting to 21 lakhs. Then a demand notice was given to them on 6th April 2023, page 44. I have not received a single reply on each or every letter which I have written to them.
The amount is
14
1448.
lakh 48,000.
Very well. Yes, your preliminary objection is refused. Any other
Another
point?
thing, my lord, the tender has been issued by WBSCTCL.
So-
WBSCTCL has not been made a party.
Oh.
I have. And it is in respect of the money which they are asking for the GST amount,
No,
if
it is not with-
kindly.
It is not with respect to GST, ma'am.
WBACDCL is not been made up. Kindly see their prayer. This is totally a prayer in respect of money, disputed question of money. Prayer A, that is at page 9.
No disputes have been raised by, I see.
But it is an admitted fact, we have paid them the amount, the tender amount.
Kindly grant me liberty to amend the cause title, my lord.
You will accept service for WBSCDCL. I'll
Right,
clarify
accept,
that.
then only kindly direct to file affidavits to this one.
Why?
I will file.
Tell me what is your objection first?
My objection is, kindly see,
What ground do you dispute?
I dispute, we have paid them the amount, that has been admitted.
14 lakh 48 also you have paid.
No, 14 lakhs 48 is in respect of the GST charges which they are claiming.
No, my lord.
There is a government circular, which I want to put in on record,
This is a post GST.
Very well. Learned counsel appearing for the respondents at the outset takes an objection as to maintainability on the ground of non-implementation of the WBACDCL against whom the claim has primarily been raised. Footstep. On the prayer of learned counsel for the petitioner, leave is granted to the learned advocate on record for the petitioner to carry out the necessary amendments to the cause title of the writ petition during the course of the day, for implement of the WBACDCL as a party respondent herein. Full stop. The WBACDCL shall regularize the appearance of learned counsel appearing for the respondents, since the respondents are all functionaries of the WBACDCL. Full stop. The matter is now taken up on merits for being heard as a listed motion. Full stop. Next para. Learned counsel for the petitioner contends that the petitioner worked for the WBACDCL and completion certificate was duly issued. Full stop. Thereafter, despite repeated representations by the petitioner, an amount of rupees 14, 48, 633.78 has still been withheld by the WBACDCL. Full stop. Next para. Learned counsel appearing for the added respondent submits that the claims made by the petitioner pertains to a dispute regarding money and as such, it is beyond the writ court to decide such factual questions. Full stop. Next para. However, learned counsel for the WBACDCL also seeks opportunity to file an opposition, for the purpose of explaining the defense of the WBACDCL. Full stop. Next para. The question raised in the present application is regarding short payment of an amount with regard to GST payments. Full stop. Next para. Since the dispute may pertain either to a pure question of law or factual questions, it would be prejudging the issue at this juncture to relegate the petitioner to a civil court. Full stop. Accordingly, the respondents, including the added respondent, are directed to file their affidavit in opposition within a fortnight from date. Full stop. Reply, if any, shall be filed within 3 days thereafter. Within 3 days thereafter. Full stop. The matter shall be listed for hearing on July 27, 2023.
Can it be 26 July?
26th, July 26, 2023.
Well, let it be 27. I remember there's a appeal, 26.
27.
I'm sorry, 27.
27th, very well.
I'm grateful.
We'll correct the cost title.
Yes, please do that during the course of the day. I have given that liberty.
15.
I appear for response.
Response.
For the petition.
Yes, what is it?
My affidavit of service.
All served?
Yes, ma'am.
Yes.
This is a case, where I have a high tension wire going over my premises.
Right.
And I had sought for removal of the same. But the problem started, my lord. What happened, my lord? Since 2012, I have been making effort to remove the wire from the electricity company and all. And in 2021, I approached this Honorable High Court. On 23rd March, my lord, the Honorable Court passed an order where it has directed that the electricity company will take steps for removal of the same, and in case of any objection from the local neighborhood people, police assistance may be given. Now, after that, my lord, I communicated the order through my London advocate on 14th of April 2021 to the electricity company. On 22nd of April, the electricity company writes back to me saying that they have faced some protests, they could not carry out the work. Well, the letter is at page 34.
My lord, still who is appearing for this state?
I've already started hearing the matter. I'm sorry. Yes.
My lord, on 26th of April, my lord, I write to the concerned police authority, my lord, saying that this is the issue. You kindly provide the necessary assistance for removal of the same. On 29th of April, my lord, I write to the electricity company saying that I have already asked the police authority to provide the necessary assistance. On 3rd of May, that is at page 37, the electricity authority informs me that since there was no police arrangement available on the 30th of March, they could not carry out the work. And after that, my lord, I am only running to the police authority, asking them for assistance. Nothing has been provided to me, no intimation, my lord. Those are the subsequent letters, my lord. And my lord, I apologize, my lord. On page 39, there is a letter written by the client, which is in vernacular. And last, as a reminder letter, my lord, at page 40, I have given a proper intimation to the officer in charge, concerned police authority, saying that this order needs to be complied. The order of this Honorable High Court dated 23rd March needs to be complied. You kindly provide the police assistance so that the electricity company can carry out the designated work.
I'll direct the police or the officer in charge. Yes, respondent number 3 to inform you about the quotation within a week from date. Communicate by tomorrow, and I'll take it up after 1 week. Learned counsel for the petitioner contends that despite a previous direction dated March 23, 2021, passed in WPA 4758 of 2021 by a coordinate bench for the WBSCDCL to carry out the shifting of high tension line passing over the petitioner's property, and to the officer in charge of the Diamond Harbour Police Station to give adequate police assistance, the same has not been complied with, full stop. It is submitted that despite the efforts of the WBSCDCL, since the police authorities have not yet provided assistance, nor given any quotation for the amount required to be paid for such assistance, the WBSCDCL is not being able to carry out the order of this court. Full stop. Next para. None appear. You are asking for an adjournment for the.
I was asking for a short passover because he's.
Although a passover is asked for on behalf of the state, such adjournment is refused in view of the innocuous direction proposed. Full stop. The respondent number 3, that is the officer in charge of the Diamond Harbour Police Station, shall, within July 11, 2023, intimate the petitioner by way of a written quotation as to what will be the necessary costs required for providing police assistance with regard to the compliance of the order of the coordinate bench dated March 23, 2021. Full stop. Next para. A compliance report shall be filed on the next returnable date before this court by respondent number 3 in that regard. Full stop. The matter shall next be listed on July 13, 2023, fairly at the top of the list for passing further orders.
If it can be on July 14th.
14th. July 14.
Obliged.
You're also on the state panel. So give your presence, ask your client, the respondent number 3 to file that report and give a quotation in the meantime.
16.
16, my lord, I am for the petitioners.
Yes, what is
Here is
that?
my, lord, affidavit of service.
Good service.
Yes, my lord,
Yes,
all
yes.
has received.
Right.
My lord, the petitioners are the, my lord, professor, my lord, who are in the government colleges, my lord, who has been
You're for the
drafted-
election commission.
Yes.
State election
You're for the
commission.
state election commission. Yes.
My lord, they have been given the duties of polling officers, my lord, in the incoming, my lord, panchayat election, my lord, which are in contravention of the, my lord, circular issued by the election commission
Where
of
have you annexed
India.
the circular?
My lord, I have annexed the circular in my present application, 101, my lord. Your lordship, kindly have a look. 102, my lord, I'm extremely sorry. It is page 102, my lord. My lord,
Yes, yes.
my lord, I'm reading it, my lord, reading it out. My lord, it is the circular dated 16th of
We have seen it in previous
Yes, my lord,
matters.
my lord.
So let us hear them. Yes.
Your lordship, may I draw your kind attention towards the judgment which was passed from our Honorable High Court, Division Bench judgment which is reported in 2023 SCC Online Cal 1460.
Which paragraph?
59 paragraph onwards, your lordship. The provisions of the 1951 Act have no manner of application to the conduct of panchayat elections. Therefore, the guidelines contained in the handbook published by the ECI cannot be applied to the case on hand, as the same has been framed in the light of the provisions contained in the 1951 Act. Since the issues involved in these public interest litigations is with regard to the conduct of the panchayat elections 2023, it would be relevant to take note of the provisions laid down under the 1994 Act and the 2003 Act for appointment of presiding officer and polling officer, as the 1994 Act has been enacted for the conduct of election to the panchayats and the municipalities in the state. Subsection 5 of Section 6 of the 1994 Act provides for appointment of the requisite number of presiding officers and polling officers. Subsection 5 of Section 6 of the 1994 Act is extracted here and hereinafter. So this Act, if your lordship has that, page number 341. It's there also, but in the book also.
The entire writ petition has been quoted.
Yes, it's Dipankar. Read, your lordship. It was a public interest litigation.
Here apparently the issue was regarding appointment at all of other persons, of these people.
Yes.
Here they're not raising that question. They say that the circular has to be complied with.
Yes.
But that circular was that of Election Commission of India, which is not applicable. Paragraph 59 clearly states that.
Achha, for that yourself.
And after that, 61 interprets subsection 5 of Section 6 of the 1994 Act.
Have you got a copy of the act?
Yes, yes. Number 341.
And you said this was issued under the 1951 Act. Yes, what do you say to this?
Now, my lord,
It a
your lordship-
Firda?
now, my lord, your lordship kindly see, my lord, page 103. My lord, this is regarding, my lord, the earlier Panchayat election. Your lordship kindly see. My lord, here it has been specifically, my lord, stated that I am directed to inform you that seniority of officials should properly be taken care of while giving election
But
related.
this is on a different footing. You are now challenging your.
No, I am not challenging that, my lord. Here, my lord, it has been stated that seniority should be maintained, and my lord, divorcing the rules, my lord, that is I am relying upon. Page 102, my lord, they has been, my lord, drafted with the election duties, my lord. That is my prayer.
These
So,
are
my lord,
two
they have-
separate things. Page 102 is regarding drafting. You're drafting at all.
Yes,
You say you cannot be drafted without following this.
yes.
Now, that is not the subject matter of page 103. 103 is you can be definitely drafted, but while giving election related duty, it should be ensured that a senior official is not put on duty under a.
Should be maintained. My lord,
Yes,
yes. So, my lord,
seniority will be maintained by them. There is no allegation that they are not maintaining seniority. You are saying you cannot be drafted at all.
yes, my lord, that is page 102,
The seniority is not regarding the drafting itself.
my lord.
You can be drafted from any cadre, any of the range of the cadre, you can be drafted. But after you are drafted, the seniority of officials should be properly taken care of while giving election related duty. It should be ensured that a senior official is not put on duty under an official who is quite junior.
Quite junior to him or her.
So that will be maintained by them, but you can be drafted all the same. No, bound by this.
My lord, I have one line to submit, my lord.
Yes.
With regard to election commission India, my lord. But with regard to state election, my lord, election commission India do not have any role, my lord, because we are guided by a separate act that is represented People's Act 1951. And my lord, because last day your lordship had observed that we are.
That order has to be recalled now.
Because we are but we have do not because district Panchayat election office direct control under
But you can take out an application for recall of that order. That should be recalled then.
because they are the direct control state election commission, my lord.
We have made representation, my lord, that they have stated, my lord, their representation is.
I'll
under
say
their
that they will comply
consideration,
with
my lord.
this page 103 regarding the seniority. There is no allegation even they're not complying.
Next matter is identical matter, same issues are there.
Next matter.
Yes,
Same-
same issues are there, my lord. The only thing your lordship
Boss,
kindly considers this, my lord, the petitioner, at least in my case, I know, they are, my lord, lecturers.
Please take the microphone, Mr. Rai.
My lord, the petitioner in my case are lecturers and senior lecturers in the different technical institute, colleges of the state. Now, my lord, they have to work as presiding officer. In one case, I will show your lordship, they are even drafted a duty as first polling officer. Now, my lord, your lordship takes up the Panchayati Raj Act, whatever is there. The BDO is the authority who is getting a pay scale. But before, my lord, this revision came into force, is 5,400 get pay.
So,
And this-
Mr. Rai, your contention is different. Your contention is that this page 103 is not being adopted.
that is also not been properly done, my lord. Your lordship kindly
That applies to this case also.
Same, my lord, the lecturers are, they are getting a pay scale of more.
She's your junior.
My lord, she is my colleague. She's my, she's my colleague, my lord, nothing more.
Same chamber.
My lord, same place, my lord, the tribunal.
The source of these two litigations are same. Then you argue, yes, complete your argument.
Yes, my lord, your lordship kindly take note.
Yes.
The BDO.
I'm hearing both together, 16 and 17.
16 and 17, my lord.
Same points involved, then I'll hear both together. Yes, what is your argument?
No, my lord, although it's not been there, your lordship will find the BDOs who are the, my lord, secretaries and the controlling authorities in the Panchayat election. My lord, they get a pay scale, my lord, at least pre-revised pay scale of 2019, 5,400. Now, the petitioners, both the petitioners, my lord, there are lecturers and professors. My lord, they get a pay scale of 6,000, 8,000 even, a great pay. I'm saying the great pay, my lord. So, undisputed fact remains, my lord, these petitioners are senior to the BDOs. Well, in terms of the pay is concerned. Well, how I could be a presiding officer or something, whereas the BDOs and others, my lord, who are in, I may not say this, maybe different service, my lord. If the grade pay is concerned, we are getting higher grade pay. My lord, we have to work under them, my lord. This is
Mr. Rai, if you are to work for election duty, then what sort of job could be assigned to you?
my lord, there are. I have a prepared.
Is there any job which is above the BDO
Yes, my lord.
regarding the electoral rules and all?
My lord, there are sector officers are there. There, my lord, even election officers in charge are there. My lord, we are not saying we are not going to do the election duty. We will do the election duty, provided that, my lord, our seniority is maintained. This is our sole claim.
So if you are appointed as presiding officer, seniority will not be maintained.
No, my lord.
In Panchayat election.
Yes, my lord.
Have you stated that anywhere?
No, my lord. I never thought this would come into picture, my lord, as because I was. If your lordship allows me, I can find an affidavit.
Have you argued in your? Have you made this? Taken this ground in your writ petition?
My lord, just a minute, my lord, I've just made something.
You did not think this should come up?
But I never think about. My lord, I've never thought about that. My lord, this is my fault, my lord. I must say it's my fault. I should.
You were relying initially on the Election Commission of India guideline.
And that a follow-up guideline.
So naturally, you did not think about this.
Yes, my lord. And next thing, my lord, I may say in parametry of the Election Commission's guideline.
BDO, this is a new, entire different ground altogether,
Yes,
Mr. Rai. If you rely on page 102, it's a different ground, which they have successfully argued that it's not applicable to your case as per the law.
To the Election Commission is not
But
applicable.
BDO being a junior officer, that is a different allegation altogether.
Absolutely.
So you have to make that allegation in writ petition at least.
Yes, my lord, I never thought this would come up. My lord, I was of the opinion, my lord, as the Election Commission notification is
In your writ petition, it has been taken.
My lord, your lordship, kindly take up paragraph 10. Your lordship will find in my petition that your petitioner further says that there are instances wherein they would force to work under a subordinate staff during conducting the polling duties. But if your lordship taken my petition, my lord, paragraph 10 at page 16.
So very well, I can clarify, Mr. Rai, that you will be appointed, but not under somebody who is junior to you.
Absolutely, my lord. Let that be there.
There is a specific.
Then they cannot be presiding officers in Panchayat election. Please take the microphone. Yes.
There is a specific.
Switch it on.
That hierarchy will be considered. So lordship can always make that observation. I will hand
Very
over that. order.
Learned counsel for the petitioner submit. Learned counsel for the petitioners submit in both the matters.
My lord, may I just interrupt you? For
Yes, Mr. Mukherjee, yes.
My lord, I think, my lord, there are two judgments, my lord, which cover this issue, my lord, of seniority. My lord, a presiding officer or a polling officer, my lord, reports, my lord, to, my lord, the election commission. My lord, does not report, my lord, to the BDO. So, my lord, this has been clarified, my lord, in two judgments of.
So they do not have to
No, my
work under the BDO in any manner.
Correct.
Achha.
My lord, so this point, my lord, that BDO is this scale, etc., my lord, does not apply. My lord, there is a 2019 judgment.
Mr. Mukherjee, would you be kind enough to supply those judgments
Yes,
either to
I have it. I have one. My lord, this is coordinate. My lord, the main judgment, my lord, is reported in 2000. My lord, I find the net is not working in your lordship's court, my lord. So, my lord, otherwise I would have 2019
yes.
SCC online, Calcutta 754.
Right.
Yes, my lord, may I hand this up to your lordship? My lord, I'll. My lord, kindly, my lord.
That will be a
Paragraph,
immense help.
my lord.
Yes.
My lord, kindly take paragraph 4, my lord. Learned advocate appearing for the Election Commission of India submits that the apprehensions expressed by the petitioners are misplaced. He submits that every effort is being made by the Election Commission to allocate appropriate duties to the officers, keeping in view the notification dated February 16, 2010, issued by the Election Commission of India. Election duties, according to him, can be divided into two parts. One is the discharge of actual polling duties at polling station. The other is the duty to make arrangements for the polling to take place smoothly and in accordance with law. Usually, officers of the state, such as block development officers, are allocated duties for the arrangement of polling. They are not involved in the polling station itself. Roughly, the hierarchy of persons allocating the polling duties are a presiding officer under whom there will be first polling officer, second polling officer, and third polling officer, and so forth, as the situation may demand. The polling officers report to the presiding officer. The presiding officer in turn report to the chief electoral officer of the state. Therefore, in such hierarchy of things, a presiding officer, the election process will not be placed below any person lower in rank. He submits that the court need not pass orders on surmises, apprehensions, and which, according to him, the present stage of the writ petition, according to him, no individual instances have been brought where a matter of. So, my lord, there's, my lord, two, my lord, limbs. My lord, two, my lord, an election process. One, my lord, is arranging the polling, and one is, my lord, at the, my lord, polling station itself.
Yes.
There, my lord, the hierarchy is, my lord, presiding officer and, my lord, first, second polling officers who report directly, my lord, to the state, my lord, election officer. So, my lord, here, my lord, they're not, my lord.
Can I record in my order, Mr. Mukherjee, that I appointed the learned advocate general?
My lord, I'm appearing. The state is a party. My lord, that's why, my lord, my lord, interrupted. My lord, otherwise I would not have. And my lord, there is a recent decision, my lord, which is of 28 June 2023. My lord, kindly, I have a copy of that.
You are appearing with Mr. Bandyopadhyay in this matter?
Yes, my lord.
So I'll include his name.
Yes, yes, of course.
Whoever else is appearing in the other matter for which you are waiting.
No, my lord, the others who are assisting me, my lord, are not engaged by the state. They're engaged by me. So, my lord, they.
Very well. I'll record the name of Mr.
Yes, Mr. Bandyopadhyay.
Along with you. So these are the two judgments.
Yes, my lord. My lord, kindly see, my lord, this, my lord, at page 2, my lord, third last paragraph, learned advocate representing the state for that the first appointment orders were generated for polling personnel from available pool of employees, including petitioner. Total number of so and so, there is requirement.
This was cited in a previous judgment, Mr. Mukherjee, but this does not clarify the situation as para 4 of the other one does.
No, it does not. My lord, I'm saying, my lord, in fact, I have another judgment which says, my lord, at this last minute, to come up and say, no, we can't go at all. But that, my lord, was not being argued. Now they're on 103, my lord, on seniority. And my lord, other than, my lord, 1951 Act, my lord, we have our own act, my lord, for the state, Panchayat Elections Act, my lord, which will govern. So, my lord.
Here the pivot is this para 4 of this judgment.
Correct.
So that
So,
has
my
not
lord,
been considered here. So I'll say that
That's,
this is not.
yes, my lord.
Yes. What is your answer to this?
And my lord, if your lordship allows me to say this.
Yes.
On the one hand, my learned senior friend appearing for the election commission says, my lord, this election commission's act is not applicable. On the other hand, the learned advocate general is saying the other way around.
We are not saying it's applicable.
If I go by the
Advocate General cannot represent the Election Commission of India. Then they will be haywire.
Absolutely not, my lord.
And mayhem.
As per the learned friend appearing for the election commission says, my lord, this 16th February 2020 notification of the election commission has no application in terms of the election Panchayat Act, whatever act is there. Now, my lord, if I take this at a face value, my lord, then, my lord, what was there in that judgment with regard to the election commission, that notification? Now, my lord, if your lordship takes up the next page with the state election commission says, the commissioner says that seniority has to be maintained. Now, my lord, I put this question there only, my lord, if your lordship allows me to say this. My lord, it may be we are doing what my learned advocate general just now said, my lord, then we should be drafted to the duties of what the BDs are doing. We are not saying we know. But there are what that judgment said. I get the judgment. There
should be drafted for the.
Well, there are two parts. One is a
yes, that I've seen. What was your statement?
The other part we can be there. We are not saying
one part is appointment engagement in the polling stations.
Other part
that is not under the state officials. So you are being engaged as presiding officer. That is at the polling stations, Mr. Rai.
Yes, my lord, your lordship will find
that is accepted from this.
In my application, I can show one of the petitioners. He has been drafted as first polling officer. Your lordship will find from my petition. My lord, if I go by this, my lord, in a polling section, my lord, there are sector officers. My lord, under them the presiding officer, there first polling, second polling, and third polling. My lord, this is a structure, my lord. Although the lordship may kindly have a look, my lord. I have prepared one thing from the orders. What I get. But if your lordship allows me to place this, my lord.
No, Mr. Rai, This probably, the judgment cited was probably in respect of a different election where the Election Commission of India was in charge.
Yes, my lord. I know this is Panchayat election,
Yes,
my
but
lord.
why shouldn't the principle be same in the State Election Commission
But
also?
if I go by that logic, my lord, the election commission is the parent body with regarding conducting election all over India. I may say this, my lord, in terms of the Act 51 Act. But if I go by that,
Not that the ratio in paragraph 4, you don't have a copy of
don't have a copy of that, my lord.
I'll take it up tomorrow. I'll keep it fairly at the top of the list. Mr. Mukherjee, can you please ensure that a photocopy of this is taken? একটা order record করো না? An interesting question has been raised in the present writ petition. Full stop. It has been argued by the petitioners that the petitioners in both the matters are senior teaching staff in government colleges and universities, and as such, cannot be recruited for doing polling duty in contravention of the notification of the Election Commission of India dated February 16, 2010, which stipulates that Group A or equivalent senior officers, including teaching staff of universities, colleges, etc., should not be drafted for polling duties in polling station premises without specific reasons to be recorded in writing by the district election officer, where such appointments become unavoidable. Full stop. Next para, it is further argued that the West Bengal State Election Commission, in a notification dated May 10, 2018, also stipulated that seniority of officials should properly be taken care of while giving election-related duty, and it should be ensured that a senior official is not put on duty under an official who is quite junior to him / her. Full stop. Next para, it is argued that both the said provisions are being contravened in the present Panchayat elections by recruiting the present petitioners for polling duty at polling stations. Full stop. Next para, the learned advocate general, appearing on behalf of the respondent authorities, has controverted such contentions and, by seeking to place reliance on certain coordinate bench judgments of this court, argues that the election procedure comprises of several facets. Full stop. One such facet is engagement for polling duty in the polling stations themselves. Full stop. Such facet of the polling duties is not visited by supervision by state authorities, who are subordinate to the polling officers in grade. Full stop. Next para. Since the said issue has arisen, the matter is required to be heard at length. Full stop. Accordingly, let the matter be treated to be heard in part and be listed tomorrow fairly at the top of the list for further hearing. Please.
Not the affidavit of service be kept to the record.
Pardon?
The affidavit of service be kept.
দুটোতে এফিডেভিট অফ সার্ভিস বি কেপ্ট, দুটো একসঙ্গে আসবে। এটা ওনাকে ফেরত দিয়ে দাও। এটা কে দিল? এটা পিটিশনার দিল।
My lord, may I make a further indulgence, my lord?
Yes, এইটা একটু ফেরত দিয়ে দাও যিনি দিয়েছেন। Please hand it over tomorrow. Yes.
I make a further indulgence, my lord. Can it be at 2 p.m., my lord?
এটা ফেরত
2 p.m. at
2 p.m. কিছু আছে কাল?
দিদি ওই দিক থেকে আসতে পারবো না, রোজ হ্যাঁ। As a lordship, whatever lordship has said, my lord, let that. Deeply.
Thank you. Doctor.
My application, your lordship, and affidavit of service. Lord, this is a case, my lord.
Yes.
I appear on behalf of WBS. So there has been, my lord, running.
Please use the microphone. Whoever comes, please use the microphone.
Asking unit, my lord.
Yes.
And my lord, regular bills were raised and that were paid by the petitioner. From my lord, September 2022, the bill which is raised, my lord, stating about, my lord, noting there LPSC charge. And if the LPSC charge is not paid along with the bill raised by the authority, that would not be received. Accordingly, my lord, page 15, my lord, since my lord, page 15, P10, annexer P1, my lord, next page, my lord, P11, page 11, that LPSC charge is raised, and from, my lord, monthly bill, my lord, from September, my lord, 1 month is received, 1 month is not received. My lord, there is stated, my lord, LPSC charge along with the, my lord, outstanding dues, 4,12,526. Although your, my lord, that bill which was raised afterward, my lord, 4,81,061 in a separate writ proceeding, it was, my lord, set aside and quashed by your lordship. And again, they have raised, my lord, along with this bill. I have made the representation to the concerned authority. As has the bill is not paid, my lord, 1 month is not paid, another month that
Why
is-
was it set aside in a previous judgment? On what ground?
I have stated, my lord, that was, my lord, bad.
You should have annexed that
Permission.
copy of the judgment.
I
It
had
has
not-
been
I
set
could not-
aside on the ground that the final assessment order was not served. We have preferred an appeal, and that is pending, my lord.
And that appeal
The
is not, my
difficulty
lord,
is that, my
order
lord,
is there, my lord. that's
none
why
of
it
the
is not-
orders has been annexed to this writ petition, my lord.
Yes.
There are checkered history,
Then, my lord,
lord.
I can place before your lordship, my lord, in a supplementary affidavit, your lordship. can listen.
Since relevant document have not been annexed to the present writ petition, comma, including previous orders of this court, comma, the petitioner is given the liberty to file a supplementary affidavit on the next date of hearing. Full stop. The matter shall next be listed under the same heading on July 11, 2023.
Your lordship.
Affidavit of service filed today be kept.
I'm grateful.
Thank
19.
Under 19, I am for the petitioner.
My lord, I appear on behalf of the state. My lord, seeking for an adjournment. My lord, need to take instructions in regard to this
My
matter.
lord, what is happening? The petitioner has got a license under the, my lord, the West Bengal Agricultural Produce Marketing.
Let her take instruction, come back tomorrow.
Tomorrow.
An adjournment is sought by the state. Full stop. Let the matter stand adjourned till tomorrow. Please take instruction by today.
Yes, my lord.
Because my lord, what is the problem we are facing? The running, my lord, what is video and OC is saying that we in not in writing but verbally. You stop it.
20.
Mr. Shukla for the respondent.
20, yes.
20, I am
20.
for the petitioner, madam. Service to the respondents has not been completed.
Service not yet completed. Full stop. Let the matter stand adjourned for the week.
Can we get the appearance from the state lordship?
Yes, yes, give your name.
I think all the respondents are appearing, Worship.
All the respondents are appearing, then move the matter. Is there any private respondent?
No,
There is no. Huh.
State is in both.
Dekhi. Yes. He is WBSCDC, she is for the state. Move the matter. আগের অর্ডারটা রিকল্ড মানে এমনি কেটে দেন yes
আমার ব্রিফটা
if you are not ready that is a different submission.
It will be taken tomorrow.
Tomorrow.
What is the matter? I'll
There's a
make
new
you
connection.
ready.
New connection.
Lordship's own order is there.
There's one
Where
order
they were-
passed by my lord.
They were directed to file fresh application. He has not made the fresh application.
Fresh
Instead of
application.
making application, he's making representation.
Representation, my lord.
The representation will not do. Lordship's order is at page 22.
Page 22
23.
starts at page 22, my lord. So starts at page
clear.
21, my lord.
Ah,
Next
page
P5.
22 is the clear order, Lordship.
I'll dispose it of. File a fresh application. Get it. Learned counsel for the petitioner submits that despite a previous order dated December 14, 2022, passed in WPA 26886 of 2022, comma, the WBSCDCL is not giving electricity connection to the petitioner, comma, although the petitioner made several representations. Full stop. Next para, learned counsel for the WBSCDCL points out to the said order annexed at page 21 of the writ petition and contends that as per the said order, comma, the petitioner was granted liberty to apply for a fresh electricity connection. Full stop. Next para, no such application in proper format having been filed by the petitioner, comma, the WBSCDCL could not process the same. Full stop. Next para, there is justification in the contention of learned counsel for the WBSCDCL, comma, insofar as This court, comma, on the previous occasion, comma, had granted liberty to the petitioner to, within double inverted, apply, double inverted clause, for a fresh electricity connection at the premises and upon compliance of all formalities and due process of law, comma, directed the WBSEDCL to give such connection to the petitioner. Full stop. Having not done so, comma, the cause of action for the present writ petition is premature. Full stop. Accordingly, WPA 15270 of 2023 is disposed of by reiterating that the petitioner will be at liberty to make a proper application in appropriate format as sanctioned by law and procedure, comma, for a fresh electricity connection, full stop. If so made, comma, the WBSEDCL shall raise a quotation accordingly, and upon compliance of all formalities, comma, the WBSEDCL shall give such connection to the petitioner, comma, preferably within a fortnight from the date of compliance of such formalities. No rest to cause suggested. Thank you.
Wait, Your Lordship.
Yes, Mr.
Application, my lord, I am for the response.
You have violated human rights.
No, I haven't
No, Mr.
violated
Bhattacharya
any
is-
human rights.
Yes, Mr. Bhattacharya.
The point is very short and simple. Kindly turn to page 168, the earlier order of this court. 168.
Yes.
I will kindly turn to relevant pages. Lordship may not be detained with the other pages. Page 173.
Yes.
Having regard to the submission made on behalf of the learned counsel for the parties, the respondents are directed to consider the representation in the form of reply to the show cause made by the petitioner by reasoned order within a period of 4 weeks from the date of communication of the order, by giving an opportunity to the petitioner of being heard, and further to communicate a copy of the reasoned order to the petitioner. Accordingly, the respondents are directed to stay their hands for a period of 6 weeks from the date thereof, and not to give effect the show cause notice that so and so. Now, this was the order, my lord. In spite thereof, the order impugned was passed, not in this petition. At page 174, the authority wanted to, my lord, cancel our linking license. At 175, they say, after consideration of the reply of the company, relevant clauses of the policy guideline, the facts and circumstances of the case, and also in view of the denial, this is the reason, of security clearance to the company by the Minister of Home Affairs, the Ministry is of the view that the company, Mrs. RP TechVision, is not fulfilling the eligibility conditions to hold the permission for uplinking and downlinking TV channel, Kolkata TV. Accordingly, the renewal of permission to operate the channel cannot be granted and be withdrawn. But this order, though they passed, they could not give effect to because of the order of the High Court. Now, what brings me before this court is at page 189. Now, this is at the show cause stage. I just cannot admit, but still I move. I tell you also the why. The show cause only talks of, my lord, dues of certain amount. At page 190, the company, clause 4, has outstanding towards annual permission fee to the tune of rupees 77 lakhs for the period from 16 to 24 and 8 March 21 to 7 March 24 in respect of TV channel, namely Kolkata 24/7 and Kolkata TV respectively. However, the company has not paid the requisite AFP yet. Hence, the company has violated clause so and so. Now that I immediately reply to this and say that we have paid the entire dues which you are asking for, that is page 226.
Miscorrection.
Now this
Correction mistake.
Uh,
Calculation mistake.
we have, my lord, pointed out and given reply. At this stage, my lord, what I apprehend that, like the other situation, they might also pass an order, my lord, asking me to delink. If the money, what they say, don't know X, Y have you paid, you want Y, we can clear it. There's no difficulty with that. But let them not, my lord, go on for delinking. And the delinking of a TV channel, even for 24 hours, would means, my lord, the TV channel is out of, my lord, commission. That's a simple. Ultimately, it boils down to the question of payment of money, nothing else.
Yes, what do you say?
First of all, premature, my lord. Show cause notice, reply has been given, adjudication process is not complete yet. Now it is premature to think that I will delink, and if he has paid the amount, why will I delink? He himself is saying that he has paid and it is adjudicated and found that he has paid. The only, if my lord sees the show cause notice.
Before that adjudication, please don't delink.
Yes,
That is, there's no apprehension of that also. Why should they even apprehend that? I have not said that I'm going to delink. Before my lord will see the show cause.
I'll record your submission on that, and
Let
I'll not
that-
record any undertaking. I'll record your submission on that.
Yes, that there is no question of
Premature
delinking
because there
before
is
the,
no apprehension.
before the completion of the adjudication process.
So how soon can you decide this?
My lord, that is.
What will be a reasonable period? You tell your period.
That, my lord, I
Have to
without
take instruction.
instructions, I cannot. I'm not in a position to say without instruction.
Yes, Mr. Bhattacharya, I'll record his submission and say that it's premature because there is no occasion to.
Yes.
No occasion for them to delink prior to adjudicating this.
But I would like to have an assurance that they will not take any penal measures relating to disconnection of uplinking.
After show
Till
cause
the
notice,
matter,
how can
till
I?
the matter is finally decided. If that is done, I am okay. Or the writ may be kept pending, let it take instruction, come back to your lordship.
My
and
lord,
see.
this,
Finally.
with regard to what my lord said, is absolutely correct. Today, before the show cause notice is decided, the adjudication proceeding is completed, there is not even a threat given of delinking. So what is the apprehension? My lord will see the show cause notice.
No, the apprehension is based on the conduct.
On the
earlier
previous
conduct.
occasion, you did so.
Yes.
No, I hadn't done even then.
No.
Even then, I hadn't done, my lord.
Why do you say that?
My lord will see the order.
Yes, yes.
When they came before, my lord, in the previous occasion, my lord will see at page 173
is the ordering portion.
It was
There
with
was a
regard
threat
to
there.
renewal. It was regarding renewal. My lord will kindly see page 170, the 172 first. The contention, the second paragraph, the contentions put forth on behalf of the writ petitioner involve arguable issues into the matter and is required to be heard on merit after exchange of affidavits. In regard to the merit of the writ application, I discovered the background facts compelling the petitioner move the writ jurisdiction of the Honorable Court. Mr. Basu, learned senior counsel, submits that the show cause notice dated so and so is illegal and without any jurisdiction. However, Mr. Basu submits that reply of the show cause notice has already been filed by the petitioner.
So I'll pass a similar orders once.
No, my lord. There the question was with regard to jurisdiction. Here there is no question of any jurisdiction here. So my lord is aware of Radhakrishna's matter. If there is no question of jurisdiction, the alternative remedy is going on and there is no threat perception. I am also saying that there is no threat. Even in the show cause notice, there is no threat given that I am going to dealing just now. Then today, if this is not premature, what is?
The grievance as ventilated by learned senior counsel appearing for the petitioner is that on a previous occasion, there had been a show cause notice issued by the respondent authorities in respect of cancellation of the license of broadcasting of the petitioner. Full stop. It is submitted that on such occasion, by an order dated October 5, 2021, passed in WPA 16468 of 2021, a coordinate bench had observed that the respondents were directed to consider the representation of the petitioner in the form of reply to the show cause made by the writ petitioner by a reasoned order within a period of 4 weeks from the date of communication of the order, by giving an opportunity to the petitioner of being heard, and further to communicate a copy of the reasoned order to the petitioner. First up, that apart, it was observed by the learned single judge that the respondent authorities were to stay their hands for a period of 6 weeks from the date of the order and not to give effect to the show cause notice dated September 27, 2021 till a reasoned decision at the end of the respondents till disposal of the writ application on merit. Full stop again,
No, an order was passed and we have not dealing. No, on that day. An order was passed.
No, I'm recording Mr.
My
Bhattacharya,
lord,
sir.
my lord.
It is submitted that subsequently, another show cause notice has been issued, which is under challenge in the present writ petition, whereby it has been disclosed that the petitioner has not paid charges for uplinking and downlinking, for which the said uplinking and downlinking would be the license would be cancelled. Sorry.
No, my lord, we'll see paragraph 7, the last paragraph, page 191. This is what has been said. So this is
আচ্ছা applicant downlink প্রথমটা যেখানে বললাম has not paid দিয়ে full stop. Accordingly, the petitioner has been required to show cause as to why the permitted TV channel within bracket S should not be prohibited from broadcasting for a period up to 30 days under clause 25 within bracket 1 within bracket Roman 8 of the policy guidelines, 2022 for violations of the clauses as indicated therein. Full stop. Next para, it is apprehended by the petitioner that, as was going to happen on the previous occasion, there is that the respondent authorities may prohibit the petitioner from going on broadcasting, despite the petitioner having clearly enumerated in their reply to the show cause, given by way of a representation, whereby it was disclosed by the petitioner that the entire amounts in question have been duly paid by the petitioner. Full stop. That apart, learned senior counsel for the petitioner, on instruction, further submits that the petitioner is agreeable on principle to pay all deficit, all due amounts, if any, from the end of the petitioner, provided the respondent authorities disclose such amount. Full stop. Next para. Learned counsel for the respondent authorities controverts such submissions and argues that the writ petition is premature, since no cause of action or apprehension regarding prohibition of the petitioner to broadcast has been expressed in the writ petition, prior to a decision being taken on the petitioner's reply to the show cause. Full stop. It is submitted that the petitioner has challenged the show cause notice itself, prior to a hearing being given on the same, and as such, there is non-disclosure of any cause of action worth the name in the writ petition for interference by this court. Full stop. A perusal of the records indicates that on a previous occasion, during pendency of a writ petition, an order has been passed to the effect as disclosed as indicated above. Full stop. On the present occasion, however, it has been rightly argued by the respondent authorities that the petitioner has preferred the writ petition at a premature juncture, since the mere show cause notice of the respondents does not tantamount to a direct threat of disconnection or prohibition of broadcast by the petitioner, prior to a decision being taken on the said reply of the petitioner to the show cause. Full stop. Since the petitioner, in the present case, has already given a reply to the show cause notice, which is elaborate in nature, as annexed to the writ petition, there cannot be any occasion for the respondent authorities to prohibit the broadcasting by the petitioner prior to coming at a decision on the said reply of the petitioner. Full stop. Accordingly, WPA 15271 of 2023 is disposed of by directing the respondent authorities to decide on the issue, raised by the show cause notice and replied to by the petitioner, upon giving an opportunity to the petitioner, opportunity of hearing to the petitioner, in accordance with law, as expeditiously as possible, preferably within 2 months, within 2 months from date. Full stop. Of course, comma, as rightly contended by the respondents, comma, there cannot arise any occasion of prohibiting the broadcast by the petitioner prior to taking a decision by the respondent authorities on the show cause notice.
I'm grateful.
No rest to cause, Sergeant Secretary.
Before your lordship, right. And next matter, if your lordship kindly takes up tomorrow.
Tomorrow?
I
Please
am
appear.
on behalf of the petitioner.
Whatever you say.
Yes, send my lord through email. I have made a request.
Board একবার একটু 22 টা দেখি 22
22.
on the prayer of you are for the
I am also for the state in this matter. Maybe day after tomorrow, have some personal difficulty. That's why. Otherwise, not.
whatever the petitioner says.
There is no problem. You should also show business note.
On the prayer of learned counsel for the respondents, the matter is adjourned and shall next be taken up on July 6, 2023.
May I permitted to mention regarding item number 13, it was deferred for monthly list of August. Just I kindly any
Whatever
any
has
very
happened.
short matter,
No.
please.
Item 23.
You're for?
Election Commission, my lord. On election in India, my lord. The petition was there, my lord. No.
Was there? Election matter, I'm making it not today only. Not today. This is also teacher.
Yes, my lord, same college.
Now this
Last,
target has
my lord,
opened.
last day, this landed advocate filed the petition, he had got the order. My lord, this Amarnath Sukul. Last day, he got the order.
That has to be the one which I said I
Yes,
may
my lord.
have
Yes,
to
yes,
recall.
my lord. Yes, my lord.
Not today. At order record, none appears for the petitioner, let the matter stand adjourned for the day. Onar namta record.
I'm grateful, my lord.
Thank you.
Twenty-four.
24, madam, I am for the petitioner, lordship. Kindly give 2 weeks time, but service has not been made, my lord.
Come back, where you will next monthly list then?
Next monthly, as
Month.
lord.
On the prayer of the petitioner, the matter is adjourned and shall next be listed in the monthly list of August.
I'm good.
Upgraded matter. Item 25.
My lord, I am appearing for the petitioner, my lord.
Yes, please, what is the matter?
My lord, we have challenged the order passed by the insurance ombudsman,
Yes.
affirming the order passed by the insurance company. Insurance company offered us to convert all the old insurance policies in a new insurance policy and to continue the new policy. But we are not in a position to continue the policy because we have been cheated by the employee and the executives of the insurance company. The facts is, my lord, the respondent number 6
Yes.
came to our house and
Who is the respondent number 6?
respondent number 6, my lord,
Agent.
Shobita Vishwadev Sharma.
She's an agent or one of the employees.
Employee of
Right. Then what happened? Yes.
came to our house and insisted us to hand it over check for renewal of the old lapse policies. So on good faith, we have signed the papers and handed over the check of more than rupees 1.5 lakhs. Thereafter, total rupees 3,18,000 we have deposited on the in the account of the insurance company for getting the benefit of the old lapse policy amounting rupees 7,62,000. Immediately after realizing that that we have been cheated by the employee and those papers we had signed and handed over to the employee, immediately after that we have lost.
What was the sort of cheating she did? I mean,
Utilizing-
you were offered that convert the old schemes to a new scheme. You did not agree to that. Then some other money was taken for the old scheme.
No, my lord. Initially, it was taken. Now, order passed by the higher authority of the insurance company. Thereafter, it was confirmed by the insurance ombudsman. Initially, it was taken by the respondent number 6 from us, utilizing the signed paper and the check, purchased more 16 policy in our name.
Achha.
After getting the new policy paper, immediately after that, we have lodged complaint before the competent authority of that is the respondent number 4 and 5, the zonal local zonal office.
Right.
Thereafter, they assured us that the money will be returned if we deposit rupees 1,58,000. Then we also deposited rupees 1,58,000 on assurance of the respondent number 4 and 5. After depositing the same, they said that your prayer is forwarded to the higher authority of the insurance company. Reply you will get your reply soon. Thereafter, after 1 month, respondent number 4 and 5 informed us that the higher authority rejected our prayer, and as there is a mis-selling of the policies, so we have given you the offer that all the old policies convert all the old policies into new policy and continue it. So we are not in a position to
and to continue the policy and to give more money. If we accept the offer of the insurance company and also accept the order of the insurance ombudsman, then we have to pay more money and to continue the new policy. Total rupees 4,75,000 we have deposited.
So there is no option to close the accounts, close the policies.
In every insurance policy, there is a clause for free looking cancellation clause. As
So
per
that,
that
for
clause,
that also you'll have to pay an amount.
yes, my lord, we have prayed for cancellation of our policies. That was accepted. After acceptance, the delay has condoned by the authority and directed to cancel all the old policies there and to convert the amount to the new policies. And my lord, kindly come to the order passed by the insurance ombudsman. That is also admitted by the insurance ombudsman, page 93 and page 77. 2 awards were passed by the insurance ombudsman in favor of the petitioners number 1 and 2. Kindly
So
come
should
to
I
the
look
page
into
93, my lord.
93. 93 and 77, same language.
Same language, same language. It is admitted fact, my lord, there's a mis-selling of the policies. Kindly come to the second paragraph. Though here is no documentary evidence provided by the complainant to prove mis-selling, however, the overall circumstances indicate that some sort of mis-selling was done by the agent for which company could not be blamed. My lord, the insurance ombudsman declared the respondent number 6 as agent, but she is not the agent of the insurance company, employee of the insurance company. Not which company could not be blamed for as they have undergone through proper procedure. That is why the forum finds no reason to intervene in this matter and mis-selling could not be proved. The company having offered to convert all the premium paid into one single premium policy, the same can be done with the consent of the complainant. And thereafter mention the policy, page 93, policies of the petitioners.
Please show me the order of the insurance company first, respondents 4 and 5.
That was not forwarded to us. It was forwarded to the insurance.
So on what basis did you approach the ombudsman?
My lord, this is the second writ petition. First writ petition was disposed of, my lord, by the Honorable Justice Moushami Bhattacharya. First, we approached before the insurance company by filing representation in
Yes.
customer care. Thereafter, the higher authority of the insurance.
What was the justice of the order of
That-
justice? What?
That is annexed.
No, that was a direction on what? On whom to do what?
Thereafter, non-consideration of the representation, we approached before this honorable court for filing a writ petition.
Ultimately,
At
there
that
was a consideration by the insurance company.
No, my lord, during the pendency of the first writ petition, award was passed by the insurance ombudsman, for which the matter.
You approached the ombudsman also.
My lord,
Yes.
if I may interject, my lord, I am appealing for the private insurance company, which is respondent number 456.
Please take the microphone. Yes.
My lord, on the earlier occasion, they had preferred a rate, not challenging the ombudsman proceeding. They were already before the ombudsman. On the same cause of action, they had come before the writ court. That
They
is
were
the-
given liberty to proceed before the ombudsman.
Right, my lord. My lord, thereafter the ombudsman had passed an order, a reasoned order. Now they have challenged that order before, my lord.
My lord, there was a direction for filing of affidavit, my lord.
So what is the primary ground of challenge? Because
Reply, my lord.
opposition has been filed here.
Yes, my lord.
Opposition kothay?
Matter was heard
Acha,
by
ठीक है.
Honorable Justice Moushami Bhattacharya on last occasion on 31st January 2023.
What is the ground of challenge? Because the ombudsman has given a detailed order. What is your ground of challenge? What is the irregularity in the order of the decision-making process?
Ombudsman, by passing the order, my lord, it admitted that there was mis-selling. There was mis-selling of the insurance policies, and the insurance company also admitted that there was mis-selling. That is why
Show me
they
that
have
admission. Show me that admission from the order of the ombudsman. Let us come to page 91.
Kindly come to the page 92. Paragraph 12. The insurance company like to submit the complainant suddenly no, my lord, sorry, kindly come to the paragraph 11. As an exception and considering the details shared by complainant, we have proposed cancellation of existing caption policies and issuance of new single premium pay policy. However, complainant denied the offer. My lord, petitioner number 1 is an acute heart patient, already has undergone heart operation under MVR process, that is heart valve replacement. So we are not in a position to deposit any amount to the insurance company. Already we have deposited 4,75,000. On assurance of the respondent number 4 and 5, we have deposited 1,58,000. They have assured that you deposit 1,58,000, you will get the benefit of the old lapse policies. And the insurance ombudsman, without verifying the document, we have the voice record of respondent number 4, 5, and 6.
That was produced before the ombudsman.
No, that was not accepted by the ombudsman at the time of hearing. Repeatedly, we have requested them, but it was not accepted.
You are ready to deposit that recording along with the device?
Yes, my lord, I have.
Then the hard copy, the SD card also has to be given.
Yes.
Yes, what do you are for the insurance company?
Yes.
You are for the ombudsman?
No, my lord, I am for the respondent number 3, my lord, that is IRDA, my lord, Insurance Regulatory Development Authority, and my lord, no relief has been claimed against me, my lord.
No, actually, yes, you are the answering authority. Yes.
My
Let
lord.
us come to page 92, 93 once.
Yes, my lord. My lord.
We all know what happens when insurance, private insurance companies sell it to their agents. So the thing between the lines are not spelled out. But we cannot proceed on that presumption. Obviously, this is a court of law. They have to prove it. But here they have voice evidence of the agent. And you have, the ombudsman has recorded that please come to the second paragraph.
My lord,
please read out.
I just read out, my lord.
Yes, please.
Though there is no documentary evidence provided by the complainant to prove mis-selling, however, the overall circumstances indicate that some sort of mis-selling was done by the agent for which the company could not be blamed. For as they have undergone through proper procedure. My lord, the language might be a little haywire. That is why the forum finds no reason to intervene in this matter and mis-selling could not be proved. My lord, just winding up the clock a little back. My lord, policies were issued in 2019. I might understand that if even beyond the free look period, from the issuance and receipt of the policy, there is a 15-day free look period which any insured can avail if they are not satisfied with the terms of the insurance contract, and thereby they can ask for cancellation. My lord, the first cancellation request comes in 2021. My lord, I can understand that the first premium was paid at the time of issuance of the policy. Now the second premium was due, not paid, no demur raised. Subsequently, when the policy lapsed because of non-payment of premium, they preferred a representation. My lord, consider this circumstance. If the contingency would have been met as per the insurance contract during that 2 years period when the policy was in force, they would have, or the nominee would have claimed the full amount. And the insurance company was bound by that contract to meet out the claim amount. My lord, after 2 years, when they had come before the ombudsman, first they filed a representation. There was a thorough internal inquiry conducted by the insurance company. My lord, all of that is there in the affidavit of opposition. We have
there is no reflection of that in the ombudsman order.
My lord, at that point of time, the ombudsman could not find any mis-selling. That is clearly out there. If today, my lord, they have come up with a documentary evidence which we are not.
What sort of documented evidence can they produce?
Yes, my lord. They are saying call records.
Agents go to the home, sell the agent policy.
My lord, there is
But
all.
you have a point when you say that they waited for 2 years before asking for.
Yes, my lord.
compensation.
My lord,
There
not,
you have a good point.
not only that, there are PVCs conducted as per IRDA regulation. Any insurance which is sold, the company directly calls up the insured to ask or rather record the satisfaction of the terms of the contract. And even if there is any kind of ambiguity in that PVC call, they could not have waited for 2 years and come up and settle the claim. My lord, at the end of the day, the forum does not find any mis-selling. My lord, I humbly bow down, my lord, whether that mis-selling can be decided by this court. If at all it is being alleged in the writ. My lord, kindly take up the prayer in the writ. My lord, prayer A. A writ and or writs in the nature of mandamus commanding the respondents not to give any effect or further effect of the award passed by the respondent number 1. Datus offering the petitioner to deposit more amount in the account of the insurance company for the renewal of the policies. And to show cause as to why the said impugned award dated has not been set aside by directing the insurance company, that is the respondent number 4, to return back the entire deposited amount. My lord, when there is a clear finding that there has been no mis-selling and all the policies as per order of the ombudsman, which we are ready and willing to comply, subject to deposit of the premium, how will, even if all the 5 policies are consolidated without payment of the premium, how are we going to cover the contingency?
How do they stand to lose if all the policies are closed today?
My lord,
lose some amount.
Huge sum of amount. And not only that, they have got the benefit for 2 years. My lord, though the benefit is not apparent on paper, but if the contingency would have arisen within these 2 years, I'm sure my learned friend or my learned friend's client would have, the nominee would have claimed the insurance amount, entire bit of it.
The coverage is also a benefit, you say?
Yes, my lord. And also, my lord, this is in the nature of tax deduction when it comes to filing taxes. My lord, this is a practice also to get insurance policies so that you can reflect it in your income tax as a tax waiver.
One other thing, there is an apparent discrepancy in this mutual contradiction in paragraph 2
yes, my lord.
Of page 93. How
Yes,
do you deal with that? Why shouldn't it be
my lord,
recent?
My lord, I humbly say.
Yes, because the ombudsman clearly says, however, the overall circumstances indicate that some sort of mis-selling was done by the agent, but it was not at the behest of the company because she was an agent only. How is that correct? She was an official of an employee of the company.
My lord, not all agents are direct employees of the company.
No, but all direct employees are employees.
Yes, my lord. Agent, principal agent relationship exists as long as there is an agency contract, whether it be third party agents or not. But whereas when the agent act beyond the mandate, that has to be proven on record to show that the agent has acted beyond mandate. And I bow down that my lord rightly pointed out that there is some kind of ambiguity regarding paragraph 2 of the award.
And this person was your employee. Is there a dispute regarding that? That respondent number 6 was your employee? She was.
My lord, we are representing. My lord. My lord,
but the ombudsman held this. She was only an agent, so the company cannot be liable. How can that be held?
My lord, I can take up the insurance ombudsman rule 2017, rule 17, sub rule 7. My lord, sub rule 8, my lord. Award of the insurance ombudsman shall be binding on the insurers or insurance broker as the case may be. The same binding nature of the ombudsman award is not on the complainant, my lord.
This is rule 7, sub rule 8.
Sub rule 8, my lord. My lord, if there are facts to the contrary.
Rule 7, sub rule 8.
My lord, rule 17, sub rule 8. My lord, it is only binding as per IRDA directive on the insurers, not on the complainant. My lord, if there is a factual discrepancy which needs to be proved, then either it has to be through a trial before a civil court or by summary trial before the consumer forum. My lord, on the basis of this award, we are ready and willing to comply by consolidating all the 5 policies subject to payment of the premium.
No, but this order does not, this suffers from mutual inherent contradiction.
Yes,
Because it says, I mean,
yes, my lord.
well, let me hear. Yes, in your
We have
reply, I'll
to-
ask you something. Would you be satisfied if it is remanded to the ombudsman because the same thing will be followed, same thing will be repeated? Now the ombudsman will be careful, and the ombudsman will not be saying that there was any apparent mis-selling. That will be rectified by the ombudsman. That will be done only. Or should I give you leave to approach the civil court? That will be a cumbersome process too.
Kindly remanded the matter to the ombudsman, my lord.
My lord, if I may point one more thing.
The voice recording, which I want to produce.
So very well,
before
get
the
your point.
ombudsman.
Yes, what were you pointing?
My lord, one more thing. There
And
is
what
no
is it?
demand for extra deposit. My lord, if may read the
Yes,
award
we'll
of
have to pay the premium now.
No, my lord, is hereby directed to cancel all the policies from inception and utilize the total amount
No.
of premium paid.
The petitioners are wanting a cancellation of all the policies.
Yes.
So they're not wanting anything else. Now, if new policies are they're made composite, there'll be a new policy
Yes.
for which she'll have to go on paying in premiums.
My lord, single premium policy from inception and utilize the total amount.
5,000.
My lord, the nature of the award is such that all the premium what has been paid is to be utilized as the single premium policy. So they don't need to pay any further money. My lord, may kindly consider
Issue one single premium policy as offered by the insurance company with the total premium paid plus total amount of renewal premium paid, if any, under the policies.
If any, if it has been paid, it will be considered that the premium has been paid for the issuance of that single premium policy.
So can I record your submission that nothing else will have to be paid by them?
Yes, my lord. My lord, that is the crux of the order.
But even if a new policy is created, that will be a policy which will bear fruit after some time.
Single
but
premium.
They won't be required to put in any further premium.
Yes, my lord.
Not a single premium.
Not a single premium.
That single policy will be for how many years?
My lord,
Grateful, my lord.
Because this person is 62 years now. If it is for another 62 years,
73 years.
My lord,
Petitioner.
my lord, generally,
73.
Petitioner number 1. And petitioner
my
number
lord,
2.
my lord, can I come back, my lord, with an instruction from the client, my lord?
If the number of years are limited and you don't have to pay anything, take instruction whether your client will be agreeable.
My client is not in a position to deposit any money, my lord, because the
He's saying that
due to
only.
medical emergency already.
They require the money back.
Yes, my lord. We are not claiming any benefit from the insurance.
Even if I remand it to the ombudsman, that will be a cumbersome process. There is no assurance that you will be getting back the money very soon. At best, the policy will be cancelled. You don't have to pay anything else. But they are saying exactly the same thing.
But the 4,75,000 then will be forfeited
Yes.
by the insurance company.
That will not be forfeit. That will be forfeited.
Yes.
No, that will go to the new policy, consolidated policy.
If we not continue the new policy, then it will be forfeited.
I'll remand it to the ombudsman.
Grateful, my lord.
Learned counsel, I'll not record your submission on that because you don't have instruction on that.
Yes, my lord.
I don't want to put
Yes,
your words on that. Learned counsel for the petitioner points out that the petitioners having approached the ombudsman, the insurance ombudsman with the allegation that an employee of the insurance company sold insurance policies to the petitioners, the ombudsman, despite having observed that the overall circumstances indicate some sort of mis-selling, comma, bypassed the issue by directing the insurance company to convert the total amount of premium paid against the policies which were sought to be cancelled and issue a single premium policy as offered by the insurance company. Full stop, it is contended that the petitioners also had voice recording of the concerned employee of the insurance company, that is respondent number 6, comma, in that regard,
Also
comma,
respondent number 5, my lord. Manager of the zonal office.
manager did not sell you the thing.
Manager of the, yes, my lord, we have the voice record of manager also. He assured us, you deposit rupees 1,58,000, you will get the benefit of all policy. That is rupees
So voice
7
recording
lakh.
of the employee of the ye na kore, voice recording of the manager of the respondent insurance company being respondent number 5 herein, comma, the same was not allowed to be produced before the ombudsman.
And also respondent number 6, my lord.
Full stop, next para. It is further contended that the voice recording of the concerned employee, respondent number 6, is also lying with the petitioners. Full stop, next para. Learned counsel appearing for the respondent insurance company submits that the ombudsman, comma, in ultimate analysis, comma, observed that there is no documentary evidence provided by the complainant to prove mis-selling. Full stop. Moreover, comma, it was recorded that the forum finds no reason to intervene in the matter and mis-selling could not be proved. Full stop. That apart, comma, it is submitted that a favorable alternative was given to the petitioners inasmuch as the total amount of premium paid by the petitioners was directed to be converted to a single premium policy as offered by the insurance company, with the total premium paid plus total amount of renewal premium paid, comma, if any, comma, under the policies to be taken into account. Full stop. However, comma, the petitioners themselves are also to be blamed, comma, since the policy was issued as long back as in the year 2019, comma, whereas the cancellation requests were made after taking advantage of the same for 2 years, comma, only in 2021. Full stop. Next para, it is further contended by the insurance company that the petitioners overshot the free lock-in period of about 15 days given after the issuance of the policy and preferred their request as long after the issuance of the policy as indicated above. Full stop. Not only that, comma, the petitioners had started paying premiums and took advantage of the insurance coverage for so long. Full stop. That apart, comma, it is sought to be argued that there are certain tax benefits also to be obtained by the policyholder, comma, which were taken advantage of by the petitioners for the 2 years for which they sat tight over the matter. Full stop. Next para. Hence, comma, it is submitted that the writ court ought not to enter into the fact-finding inquiry which would be required to go into the merits of the case. Full stop. Next para. A bare perusal of the impugned awards shows that the ombudsman arrived at contradictory findings. Full stop. It is implicitly contradictory that the ombudsman, comma, in the same breath, comma, observes that though there is no documentary evidence provided by the complainant to prove mis-selling, comma, however, comma, the overall circumstances indicate that some sort of mis-selling was done by the agent. Full stop. Next para. However, comma, thereafter the ombudsman again proceeds to observe that it found no reason to intervene in the matter and mis-selling could not be proved. Full stop. That apart, comma, the ombudsman also observed that the mis-selling was done by the agent, comma, for which the company could not be blamed. Full stop. However, comma, there is nothing on record to distinguish between the capacities of the respondent number 6 as an agent of the insurance company and an employee of the same. Full stop, be that as it may, comma, in the absence of detailed consideration on such issues, and since the ombudsman did not give any opportunity to the petitioners to produce their voice recordings along with relevant backup data, comma, the matter is required to be reheard on merits by the ombudsman. Full stop. Accordingly, without going into the merits of the matter at this stage, comma, WPA 23148 of 2023 is allowed, comma, thereby setting aside the impugned awards and directing the insurance ombudsman to rehear the parties and, comma, upon giving fresh opportunity to the parties to produce further evidence, comma, including voice recordings if any available, comma, to decide the issue afresh in accordance with law. Full stop. It is made clear that the ombudsman shall enter into all issues raised by the parties, comma, including whether the respondent number 6 sold the policies to the petitioners and whether the respondent number 6 acted in the capacity of merely an agent or an employee of the insurance company, as well as whether there actually was mis-selling on the part of the insurance company. Full stop. Next para. Upon specifically deciding such issues, comma, without being unnecessarily influenced by any of the observations made herein, comma, the ombudsman shall pass final reasoned orders in respect of both the petitioners. Full stop. The entire exercise, comma, it is expected, comma, shall be concluded within 2 months will be reasonable.
Well, 3 months, I guess.
Within 3 months from the date of ombudsman is not represented here.
No,
Within
my
3
lord.
months from communication of this order to the ombudsman. Full stop. The petitioner shall communicate this order to the ombudsman, who shall act on the server copy of this order without insisting upon prior production of a certified copy. No orders to cause urgency report.
I am grateful, my lord. My lord, there is a direction on 31st January 2023. The Honorable Court directed the respondent number 4, 5, and 6 to pay cost of rupees 10,000. I don't know whether they have paid the cost or not. For delay of filing of affidavit to the Ramkrishna Mission.
Show me the receipt.
My lord, I think it had probably skipped the knowledge, my lord. My lord, we will deposit and my lord, will show.
File a contempt application before the court. You'll have to pay more probably then.
My lord, we will deposit. My
Comply
lord.
within a week. I'm not putting anything in my order.
Grateful.
Grateful, my lord.
How next?
26.
Yes.
I'm for the petition.
You're for the petitioner? Yes.
2 times, sir.
What idle and hollow formality? What is the idle and hollow formality here?
Well, petitioners,
Use the microphone.
the petitioner owner of the land, in front of there is a public road. And the private respondent 9 to 12 illegally constructed the sub-room and totally closed the ingress of the petitioner, also closed the drain system, which is only way to to drainage whole area, water of the whole area through the drain line. It is closed as such the petitioner land is fully in water and not fit for cultivation and also fishing in
So which
pond.
of the authorities has to take action?
Respondent number 2 or 3 or 3 as per provision of law. 3.
This is unauthorized public land, unauthorized document. 1962.
Yes, madam.
Yes, what do you say? You are for the?
Private parties.
It's why you're obstructing.
Mala, there is a construction over there 30 or 40 years long back. And there is also the other way to enter into the petitioner's house.
Also totally close the drain.
I'll direct the magistrate to hold an inquiry. And the petitioner has raised an issue that the private respondents, allegedly, have made a construction on a public land, thereby obstructing the drainage system in the area and the ingress and egress of the petitioner to her premises. First of next para, despite representations, it is alleged that no action has been taken by the respondent numbers 2 and 3. First of next para, learned counsel appearing for the private respondents denies the said allegations and submits that the construction has been made in due process of law. First up, however, at this juncture, it would be premature to enter into the merits of the allegations made by parties, since a consideration of the allegations made by the petitioner in her representations and a due inquiry in that regard would suffice. First up, accordingly, WPA 25262 of 2022 is disposed of by directing the respondent number 2 to decide the representation annexed to the present writ petition, given by the petitioner on the allegation of the private respondents having made unauthorized constructions on public land and, upon holding a due inquiry on giving adequate opportunity of hearing to both the disputing parties, to arrive at a conclusive finding in that regard. First up, in the event respondent number 2 is of the opinion that a report is to be sought from the concerned block development officer, BLLRO, the same shall be called for by the respondent number 2. First up, next para, it is expected that the said exercise of completing the inquiry shall be done within 1 month from the date of communication of this order to the respondent number 2. First up, if upon such inquiry, it is revealed to the respondent number 2, that is the district magistrate and collector of Purbo Midnipur, that any violation of the eviction of the public land within eviction of unauthorized occupants act bracket closed 1962, due process of law shall be followed by the respondent number 2 and eviction proceedings shall be initiated in that regard expeditiously. No orders to cause certain settlement. Please communicate this order for compliance. Thank you.
Affidavit service kept it.
Affidavit service file today be kept on.
27.
No, I'm for the respondent bank. My lord. I am for the petitioner. My lord.
I am appearing on behalf of the 5 and 6, my lord, developer. My lord, on behalf of Nimis Mishra, my lord, leading counsel.
On behalf of?
Nimis Mishra, my lord.
Yes.
My lord, due to his, my lord, son, my lord, admission for the, my lord, out of station, my lord, Bhubaneswar, my lord. Today night, my lord, informed 1 week's, my lord, adjournment. Kindly.
Depending on the petition, if there is
I am opposing, my lord, strongly. My lord, because my lord, the reason is, my lord,
yes,
I am, my lord, the landowner.
Right.
I am the joint landowners in respect of a property in Bardhaman. Now, your lordship will find, my lord, my learned friend's client is the private respondent. My lord, we enter into a development agreement and a power of attorney, the usual transaction. My lord, subsequent to that, my lord, I do not know whether he has mortgaged or not. My lord, we come to know there is a transaction between the bank and the borrower, and then, my lord, there is a loan agreement between them. My lord, they approach the DRT. Lord, bank initiates action against them under the SABYASACHI Act. Lord, they approach the DRT. Lord, the matter is pending before DRT. Lord, my question here is, my lord, I am the exclusive owner of the land. My lord, I mean to say, my lord, all the petitioners. Now, my lord, in pursuance of the development agreement, my lord, the land has already been demarcated as 35% as the owner's allocation and 65% as, my lord, the developer's allocation. And I'll show to your lordship, my lord, the relevant, my lord, provisions, my lord.
What is the present, what has been done by them at the present?
Now, my lord, there is a section 14 order, my lord, which says that, my lord, the entire property, my lord, will be taken possession of.
So why don't you go before the tribunal?
Yes, my lord. Now, the first issue here is, my lord, the DRT2 is not functioning.
No, no, my
But
DRT2 is very much
it
functioning.
is functioning through the virtual mode in Jalpaiguri. That's the first contention. Now, my lord, the second contention is, my lord, I have an unfettered right over the land. My lord, there is no mortgage with me. There is no loan agreement with me. Neither am I a beneficiary to the loan
So
agreement.
you have a demarcated share.
Yes, my lord, I'll show from the
And
documents.
the section 14, the award has been passed regarding the entire property.
Entire property.
What is your defense to that?
My lord, preliminary is that, my lord, due to development agreement, my lord, they have mortgaged the entire property to the bank. My lord. Let me finish. And my lord, prior to going to the merit of the case, my lord, when in 2021, the 13-4 initiated by the bank, my lord, they are very much aware, my lord, they are annexing the same, my lord. And as per section 17 of the, my lord, the SABYASACHI Act, my lord, they are very much entitled to go before the tribunal, my lord. Because, my lord, more than 3 crores and 9 lakh rupees is due on the part of the, my lord, development company.
But these persons have been producing, you have produced your deed also here.
Yes, my lord, there is
It
a
is there
separate
at the
agreement for
developer's
allocation.
agreement is
We are
there.
in possession. Yes.
Landowner's allocation is there.
My lord, I'll show from
Please come to page 33.
not clear, my lord. And my lord, page 6.
But your remedy lies before the tribunal.
In
You have a
any
right.
event, my lord, today what will happen? My lord, if your lordship delegates me, the section
Chose
14
not to
application.
go before there.
My lord,
Section 17 is there here also.
No, no, my lord. Section 14, my lord, not annexing. They are
Lord,
saying section 14 order, my lord, has come subsequent to the writ petition. How can I annex it? My lord, I have to use a supplementary affidavit. That is why I mentioned the matter yesterday, my lord.
Petition is your challenge is maintained before the tribunal under section.
Kindly appreciates one thing. I will go before the tribunal, but till such time, my lord, I have to be
But
protected.
everybody will say that come before the rich court, get an order without any factual consideration and
My lord,
have this
kindly
protection.
appreciates, my lord. Today, my lord, there is a.
Why did you choose not to go there?
My lord, kindly appreciate.
We could have filed the application. If it was not heard, we could have taken care of
Lord,
that.
this essay is already filed. Now, what is
When
more
was it
important
filed?
here, my
When
lord,
was it filed?
my lord, kindly sees, my lord, kindly sees the order passed in the essay, which is also, my lord, suppressed by the bank. Now, there is an order of stay, page 89. Now, my lord, I do not know how they can proceed because I am not a party to the proceedings. Kindly sees, my lord, page 89. And thereafter, I will show your lordship, my lord, the order passed by the learned magistrate, my lord. Not magistrate. Under section 14.
That was long back.
Yes, long back. Now the question is, my lord, kindly sees page 90.
After that, my lord, DRT is not functioning, my lord. 2 days is already, my lord, adjourned for the same purpose, my lord. My lord, order was passed, my lord. Even also, my lord, as per my lord, DRT order,
I'll give them 1 month's protection and give them the opportunity to approach. The DRT is not functioning, both of them.
DRT2 is functioning, my lord. My lord, if my lord going through the website, my lord, DRT2 is costly from 3 p.m. My lord, he is steering today. Not only in respect of urgent matters and my lord, that too in the virtual mode.
Did the urgency before there?
If they are filing before this, my lord, let them undertake that they will not take any coercive action against me.
Counsel for the petitioner contends that the petitioner entered into an development agreement with the private respondents, full-stop, pursuant to the said agreement, comma, the petitioners are the owners of
The joint owners of my lord, the property.
the joint owners of a major portion of the property, full-stop, next para, even without the petitioners being liable to pay anything to the bank in any manner whatsoever, comma, apparently the developer entered into a mortgage with the bank as a security of some loan.
That is, my lord, for my lord,
Apparently.
he say, my lord, that
Apparently.
because the title deed is with us. Because what will happen, my lord, if your lordship says that there is a mortgage, valid mortgage, tomorrow, my lord,
I did not say there's a valid mortgage. Apparently, there's a mortgage sentence in Ki bolam bolo? A mortgage with the bank, comma, depositing the title deeds as security for a loan. Full stop, next para. However, comma, it is clarified that the petitioners have not got any intimation regarding any such proceeding. Full stop, all on a sudden, comma, the petitioners came to know that an order has been passed under section 14 of the SABYASACHI Act 2002 in respect of the property, comma, of which the petitioners are the owners. Full stop, it is argued that since the petitioners were never the borrowers from the respondent bank, comma, nor were the properties given in mortgage by the petitioners at any point of time, comma, the possession thereof is being sought to be taken by the bank through the tribunal. Full stop, next para. It is further argued that the regular tribunal is not functioning and, comma, as such, comma, the petitioners were constrained to move this court with the present writ application. Full stop, next para. Learned counsel for the private respondent stroke developers seeks a fortnight's adjournment Full stop. However, comma, it is submitted by learned counsel for the developers as well that the concerned bench of the tribunal is not functioning regularly. Full stop. Next para. Such contention is controverted by learned counsel for the bank, who argues that the tribunal is fully functional at present. Full stop. Be that as it may, comma, since it transpires that the petitioners have been able to show the semblance of a right in the property, and there is nothing on record to indicate that the petitioners had ever taken any loan from the respondent bank, comma, even without going into the merits of the matter, comma, the petitioners deserve an interim protection till they move the concerned tribunal with the issues as raised in the present writ petition. Full stop. Next para. Accordingly, WPA 2114 of 2023 is disposed of, granting liberty to the petitioners to approach the concerned tribunal with a proper application under section 17 of the SARFAESI Act 2002 and, comma, if necessary, comma, to make an application pleading the urgency and asking the tribunal to take up their application on an urgent basis. Full stop. Such application shall be made by the petitioners within a week from date. Full stop. Next para. However, comma, for abundant caution, comma, the respondents shall remain restrained from disturbing the possession of the petitioners in any manner with regard to the disputed property till 1 month from date or until further order passed by the tribunal, comma, whichever is earlier. It is made clear, comma, however, comma, that the merits of the matter have not even been gone into by this court on a prima facie footing, and the findings made above are entirely tentative in nature, and the interim order is ad hoc, comma, subject to the adjudication by the tribunal. No address to cause.
No affidavit, my lord.
Since no affidavits have been invited, comma, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents.
Intelligence, my lord, before your lordship, my lord. If they are not moving within 1 month, my lord, the bench is regular, my lord.
Very well.
Kindly, he says that if we do not move, not once we file, once we give a put up application, it is not within our domain, my lord.
It's made clear that in the event the petitioners do not make such application before the concerned tribunal within a week from date, comma, this order shall automatically stand recalled without further reference of the court, and it will be deemed that the writ petition has been disposed of only with the liberty to the petitioners to move the appropriate forum.
And deeply.
28.
Yes.
Time for the petitioner.
Yes.
Well, the petitioner was traveling abroad. He was
Respond number 1 to 4.
LOC.
not LLC. It's a stamp. It has been stamped. His passport has been stamped with CPWOD, the cancellation without prejudice. And the respondent number 1 has informed that you have a dispute with your bank. Kindly settle that and let us have an instruction. We will withdraw it. Now, in the meantime, what happened? My lord, kindly come to page number 15. No due certificate has been issued. Whatever issue was there with the bank has been resolved, and it has been duly communicated to the respondent time and again, but they are not acting upon.
You are appealing for the bank.
I appear for the bank.
Oh, you are for the bank. Who is for the respondent number 1?
There is one.
Please take the microphone.
But passport and visa is valid.
Passport and visa
is valid.
What about the stamp?
Stamp so far, stamp is concerned. Here, annex in the petition.
Yes. That is page number.
I did not find.
Yes, that is page number 16 and 17. I can show the original passport and the stamp as well. I mean the boarding pass.
His boarding pass and offloaded is there.
Yes, and in the passport it has been mentioned. The stamp was there. CWOP, cancellation without prejudice.
Boarding pass. But you have not annexed a photocopy of this?
Yes, I have annexed. That is page number 16. I think the photocopy.
16 is the boarding pass.
Yes.
Oh, no. Very well, yes. It's there at the top.
CWOP.
It's a mirror image sort of.
Malad, it's-
At page 16 at the top, there's a
Malad,
mirrored
it's-
image of the letters
Yes, this one.
CW.
You can have an inspection.
ঠিক আছে। Malad, in that case, Malad, if there is no any other reason,
No, what is the basis of putting this stamp at all? When do you put this stamp?
Malad, when Malad, he Malad, for Malad, 20th of January 2023. But thereafter, Malad settled the issue Malad 28th of March 2023.
No, under the law, do you have any option to, if a bank, they do not pay an amount to a bank, you can cancel the passport without prejudice. What is CWOPD?
Cancel without prejudice.
What is the meaning of cancellation without prejudice?
Malad, to that effect, Malad, I already Malad sent for instruction.
What is cancelled without prejudice? What is the effect according to you?
According to me, it's that there's an instruction from them that without cancellation of recalling of that instruction, they will not allow the petitioner to travel abroad.
Without prejudice to whom?
Without prejudice for the time being. It's not that the passport has been impounded or like that.
Yes, I'll set aside the cancel without. You are of the opinion that they have cleared the amount.
Yes.
If there is any other reason.
Even if they did not clear the amount,
and
where is the occasion of
I have
putting the stamp? By the Foreign Office?
Immigration Department does put.
But then caustic remarks have to be put in. Why? What is the jurisdiction under which you do this? Suppose they have a loan with a bank. This is not an LOC. Do you have any guideline for this?
Malad, if you notice kindly.
Mr. Rai, did your bank ask for this?
Lord, we had Lord asked for issuance of LOC. Lord,
Yes,
as
right,
I said,
right.
Lord, this CWOP, Lord, Lord, I don't have any knowledge of this.
I set aside. Affidavit of service filed today be
Yes.
kept on record. First off, the petitioners argue that without any prior warning and in an unwarranted manner, when the petitioner, you had boarded the plane.
Yes, I was offboarded.
When the petitioner number 1, why is the petitioner number 2 a party? The company was also
Company, the dispute was with the company for that reason.
Achha. The petition number 1 was made to alight from the aircraft, and the petitioner's passport was stamped with the letters CWOP within bracket cancelled without prejudice, bracket closed. Full stop. The petitioners also rely on a photocopy of the said page of the passport as well as a copy of the boarding pass with the stamp within double inverted offloaded, double inverted close. Full stop. It is argued that the apparent allegation against the petitioners was that the petitioner number 2 company had, you are the director. The petitioner number 2 company, of which the petitioner number 1 was is a director, had certain loans with the respondent bank which were not cleared. Full stop. However, it is contended by learned counsel for the petitioners, by placing reliance on annexure P1 to the writ petition, that a no due certificate was issued by the respondent bank, that is the Indian bank, on March 28, 2023, and as such, the same could not be a basis of the impugned action of the respondent number 1. Full stop. Next para. Learned counsel appearing for the bank reiterates the submissions of learned counsel for the petitioners to the effect that the petitioners have cleared all the due loans with the respondent bank. Full stop. Next para. Upon hearing learned counsel for the parties, there appears to be no conceivable reason for putting in the stamp CWOP on the passport of the petitioner and or deplaning the petitioner, deboarding the petitioner from the plane in any manner whatsoever. Full stop. The petitioner number 1, comma, in his rights as a citizen of India and as a corollary to his right to life under Article 21 of the Constitution of India, comma, is entitled to free movement within the country and abroad. Full stop. Since the petitioner number 1 had a valid ticket on an aircraft, comma, there was no reason for the respondent number 1 to make the petitioner alight from the aircraft and or put the impugned stamp on the passport of the petitioner. Full stop. At the most, comma, under certain circumstances, comma, governed by the corresponding guidelines issued by the government of India, comma, the immigration authorities have a right to issue an LOC at the behest of the appropriate authorities of a bank, comma, upon the satisfaction of the stipulations given in the said guidelines. Full stop. However, comma, in the present case, comma, there is nothing to show that the occasion arose for the occasion subsists for even issuing an LOC to the petitioners, comma, let alone putting an unwarranted and unsolicited stamp within double inverted cancelled without prejudice on the petitioner's passport and or to compel the petitioner to leave an aircraft. Full stop. Next para. Hence, comma, the impugned action is palpably dehors the law and without jurisdiction. Full stop. Accordingly, WPO 12800 of 2023 is allowed, comma, thereby setting aside the impugned action of the respondent number 1 and directing the respondents not to impede or restrain the petitioner number 1 from leaving the country in any manner whatsoever and to restrict the free movement of the petitioner within and outside India. Full stop. Next para. The stamping within bracket CWOP shall be deemed to be quashed with immediate effect. Full stop. The respondent number 1 shall, comma, if necessary, comma, in cooperation with the appropriate authorities, comma, issue a fresh passport or a clear indication in writing as regards the said stamp within bracket CWOP bracket closed being ineffective. Full stop. Such exercise shall be completed by the respondent number 1 within a fortnight from date. Full stop. Next para. It is made clear that the respondent number 1 shall not repeat such futile exercise in future without any basis and dehors authority. Full stop. Nor as to cause urgent certified copies.
Only one request, Lord, where your lordship has recorded my submission, Lord, reiterating his, not having paid all the loans, Lord, only one, Lord, loans as per the settlement, Lord, because it was
in terms of P1.
in terms of the settlement.
Learned counsel for the bank reiterated third ki fourth paragraph e police. Learned counsel for the bank petitioner submission sheshor por learned counsel for the bank reiterates the submission to the effect that তারপর কি বলেছি to the respondent in terms of the settlement between the bank and the petitioner.
Petitioner number 2.
And the petitioner number 2. Between the bank and the petitioner number 2.
My lord, may I have submitted before you, lordship, one thing. My lord, he was, my lord, devoted on 28th of my lord, January 2023.
He cannot be. That
No,
cannot.
Thereafter, loan has been paid.
Even if they don't pay the loan, you cannot do that. Unless you issue an LOC, you cannot do that. Where is the LOC?
Great.
You cannot devote a citizen of India just like that. Yes.
Original side matters.
Lordship, may I be permitted to mention item number 9, Lordship?
Yes.
Oral submission has concluded. Lordship had only directed for filing a short written notes. Mr.
You are
Mitra
for
had
the
concluded.
petitioner.
I am for the writ petition.
What about the other side?
Other side, I will give a copy, Lordship.
Please wait till it is called on. If it is not called on today, then tomorrow just mention it when I take up the original said matters. Give a notice to the other side so that I can conclude the hearing. I mean, officially. Yes.
State matter for hearing item number 1, Shyam Takniki Udyog versus Union of India.
Yes.
May I file a short affidavit?
Is it Chakravarti appearing in this matter?
Yes.
Yes.
No, the only point that on the last occasion, had been placed to ask is
Kunta tumra?
Yes.
whether on the basis of establishment, whether the bank guarantee and the security money get completed. Date of
Item number
interim
what?
order.
My lord, I wrongly given it. Affidavit taken and two te.
Terms of
Mr. Chakravarti, please take the microphone. Please give him the mic.
My lord, sorry, affidavit is a matter of two, item number 2. I thought item number 2 is being taken up.
No, the petitioner was granted a contract for execution of electrical lines from Noihati to Ranagar. Now, under the general condition of contract, there was a clause that he has to complete the work within 1 year. He failed. We granted 8 times extension for completion. Even thereafter, he failed. And then a so-called notice under the contract was issued, and 7 days notice and 48-hour notice, and the contract was terminated. And after the termination of the contract, he came before the Honorable Court and got an interim order, because the last extension was for a period of further 1 month. And during that period, the contract was terminated. Now, in terms of the interim order passed from time to time, he has completed the work now. This whole question remains whether we can take benefit of termination and the security money and the earnest money. That is the sole question now left. Let my learned friend say something, and then I shall satisfy Lordship. What is the date of the order of cancellation of contract, and what is the date of the interim order?
Lordship, may I? Lordship, straight away, Lordship, I'll take you, Lordship, to the clause of extension, which is at page 66. The agreement starts from page 34, but Lordship need not bother about the entire thing. Page 66 is the extension clause. Lordship will only mark clause 17A and 17B, 66 and 67. These are the 2 clauses. I'm not placing these clauses at the moment because these are not, I'm not disputing these clauses. Now, Lordship, with no, I'm not going, this agreement was entered into in 2017. I'm not going into that aspect of background of this matter. Straight away, Lordship, I'm coming to the first notice. I'm starting from the extension letter at page 187. This is my letter at volume 2. This is the letter I gave for extension. This was the last extension which I sought for. 187, Lordship, will kindly have a look. Dated, Lordship will mark the date 25th July 2022. Second paragraph, with regards to the execution of works, we like to mention that we have supplied all the major quantity as per schedule. Drawings of all the yard have been prepared and approved, except one which is also in final stage. Works in full pace is going on site. Recently, NI at Halshihar has been successfully completed. Some delay has been caused in execution of foundation works at site, because when we started work, we had to face heavy rains and some local festival. However, we have taken up the work and desired pace will be attained very shortly. Meanwhile, we request you to consider the contractual work within the stipulated period cannot be completed, and hence we request you to please extend the completion time for further 6 months up to 31st January 2023. Lordship, this date is important also. By which date we shall complete the entire work and close the work order. Now their response is the next page, page 188. This is dated 27 July 2022.
Extension was given up to 31st January.
Yes, but I need to read this because entire gamut is on this letter.
Very.
In terms of the subject agreement, by reference to the above stipulated completion of the subject was 22nd October 2018. However, the work was not completed on that date. Now, in consideration of your request for extension of the completion period, the competent authority is pleased to grant the extension of completion period without liquidated damages. It may be noted that unless repugnant to the context, the terms and conditions of the contract will remain unaltered during the extended period from 1st August 2022 till 31st January 2023. No increase in additional rates and claims or recoveries which have already been envisaged in terms and conditions will be leviable either by you or by the purchase in respect to the extended period. Now, so it has been extended unconditionally without liquidated damages based on my letter. So there is no allegation as against me as on 27th July 2022. Now, Lordship will come to page 177. Few communications thereafter, which I presume the respondents might show. Page 177 is a 7 days notice under clause 62. Now, all these communications are in that period of extended period. Lordship, second paragraph. Hence, you have failed to abide by the instruction issued from time to time. To show adequate progress of the work, you are hereby given 7 days notice in accordance with clause 62 to commence work and make good the progress, failing which further action provided in clause 62 to terminate the contract and balance work without your partition will be taken. And now all these letters, my contention, all these letters are bad by virtue of the extension that has already been granted. Now, Lordship will see this notice has been issued on 2nd of August 2022. I replied to them next page at page 178 on 3rd of August 2022. Detailed reply. I'm not going into the merits of this reply. These third paragraph at page 178, I specify that amount is due from 2019 onwards. These are all there. According to me, these are also not relevant because now Lordship will see the mark the work date 3rd August 2022. Nothing done within that 7 days period. So that clause of 7 days notice also, although I say it is bad, that notice, even then they do not do anything with regard to that 7 days period. Now again, on page 180 is the notice dated 15 September 2022. Again a 7 days notice. Second paragraph, 7 days notice hereby given. 15 September 2022. I reply to them next page, page 181, 21st September 2022. Seven days, that period also gets over. They do not do anything. On 28th September 2022 at page 183, we issue a letter. Fourth paragraph, it says the average rate of foundation of casting is not sufficient as per target. You have failed to comply with the commitment.
Yes.
Now, there are two letters, 183 and 184 in that aspect. I reply to those as well at page 185. They again give, now page 189 is a 48 hours notice. Dated 29 September 2022. This is also in terms of clause 62. I'll place that clause 62. This notice I also replied by way of the reply at page 190, 2nd October 2022. On the same day when the 48 hours notice has been issued, they terminate the contract. Lordship will see page 193 is the termination notice. It's 4th October 2022. I issue the letter on 2nd October. They terminate the contract on 4th October.
So kept their word this time.
Yes, kept their word this time.
Yeah. Clause 62 becomes vital.
Yes, clause 62 becomes vital. Now, Lordship will see clause 62 is at page 91. Ninety. Determination of contract owing to default of the contractor. Lordship, towards the end. Subclause one, many things I am not reading the entire.
So read the worst clause against it.
Yes, the worst lordship, they will be relying upon at page 92. First paragraph. Then, and in any of the said clause, engineer on behalf of the railway may serve the contractor a notice in writing to that effect, and if the contractor does not within 7 days after delivery to him of such notice proceed to make good his default, insofar as the same is capable of being made good, and carry on the work or comply with such direction as aforesaid to the entire satisfaction of the engineer, the railway shall be entitled, after giving 48 hours notice in writing, under the hand of the engineer, to resign the contract as a whole, or in part or parts, after expiry of 48 hours notice, a final termination notice should be issued.
No, Mr. Shah, this begins with then.
Yes.
Which of the previous clauses is applicable to you?
Now,
you did not do the work within time as per them. The progress was not satisfactory.
Failed, I presume, because nothing has been mentioned in their notices, but I presume they will come up with regard to the clauses with completion of the time, the time frame. That will be 8 probably. Margin of 10% stipulated period.
Failed to adhere to the agreed.
Yes.
Very well.
Now, my point, my argument would be, lordship, twofold. First, these clauses.
They may also say persistently disregard the instructions of the engineer.
Yes.
Because they have touched that also in the letter.
In 2 of the letters.
Yes.
Now, my argument is twofold, lordship. First argument is, this clause with regard to 62 does not come into the picture during that extended period of contract where I have been extended without liquidated damages unconditionally based on my request letter. And my request letter says, because of certain faults on behalf of them, I could not complete the work.
So, Shah, tell me something.
Yes.
What is the effect of this extension of the period of contract? The original contract period, suppose, ended on some date.
Yes.
The extension only postpones that date to some other date.
Absolutely.
So the rest of the contract remains as it
remains unaltered.
So suppose, let us proceed on the premise that the extended date was the last date, original last date of the contract.
Yes.
Even on such premise, why can't they resort to 62?
No, if I have been.
Suppose that was the original last date.
I take it, lordship.
Yes.
If the original term is 1 year,
yes,
and I could not complete the work,
yes,
at the end of the 1 year, they will terminate the contract. I bow down. There is no difficulty. But before that ending of 1 year, by the question that arises, can they terminate the contract?
No, under 62, why can't they? Because under 62(1), suppose the last date becomes the newly extended date. That is the original last date. Let us proceed on that premise. Even then, if that is the last date, so under 62, there can be a determination of contract owing to a default of the contractor, one of which is failed to adhere to the agreed program of work by a margin of 10%. So you say this clause is also rendered academic by the extension.
Yes, because the reason that is why I read the extension letter. My reason of the extension was because of your fault I could not complete the work. And they in their extension letter have said because of your letter I am extending. They do not say that Roshi will kindly come back to their
they proceeded
extension.
on that premise that your letter is correct.
That
has been accepted.
Yes, there is no allegation as on that date that I have not been proceeding with the work in the appropriate manner.
How many days after that they issued the extension was issued on in July, sometime in July 22?
The extension was issued on 27th of July 2022.
And 2nd of August itself they give this letter.
Yes.
So there was no time for
there was no time for me to do anything. So my twofold argument is that once these letters are OCOs, because these letters could not have been issued during that period of where I'm doing the work, and they have extended without any kind of additional conditions and without liquidated damages. And my second limb of the argument is, even assuming but not admitting those letters have been issued, the first 7 days notice, they lose the time. They could not have proceeded with it because that 7-day period gets over.
No, it's a new cause of action every time they give a letter.
Again, the second day notice, 7-day notice comes, they also lose that period.
They lose 3 or 4 periods.
So,
But on the last occasion, that was complied.
no, the last occasion was not a 7-day notice. It was a 48 hours notice that they complied. Before that, the 7-day lordship will have look at that.
That 7 days had expired.
Expired.
Now, after the expiry of the 7 days, why can't they do this? Let us come to that clause once.
Yes, yes. Lordship will see, does not within 7 days after delivery to him of such notice proceed to make good his default insofar as the same is capable of being good and carry on such and such. The railway shall be entitled after giving 48 hours notice. So it is to be read in this manner. 7-day ends. He gives me 48 hours notice.
May not be immediate. If you have to do it within 7 days, that's the cutoff outer limit for you. You fail to do that. After that, after a few days, they can give this 48 hours.
She will visualize situation. So if that is taken into account, I proceed to complete the work. I proceed go on working in the manner which I am doing, and they do not take immediate steps after that 7-day. And suddenly they come up with another 48 hours notice in the period when I'm doing the work. Because my letters on record say I'm going doing the work. That is why I produce those letters on record. I'm proceeding with the work.
So notionally, this 48 hours notice can be given even after 1 year.
Exactly.
That expiry of 7.
Exactly. Exactly. That is what I was saying, Lordship. But my first limb of the argument is these notices could not have been issued during this
That is
period.
always. Mr. Shah, can you give me 2 dates? When was the last 7-day notice issued?
Last 7-day notice was issued on
The documents you are reading out.
15th September 2022 at page 180. And thereafter, the 48 hours notice is at page 189 on 29th September 2022.
That is page 180?
189.
So 29th September.
Yes.
So
14 days. Nearly 14.
Plus
15
7
days.
is 22nd. 22nd, that 7 day expires.
Yes.
They've given this notice on 29th. After further 7 days.
For the 7 days.
That's reasonably proximate.
And that is why in first limb, I am going back to the first limb of the argument that I am proceeding with the work. The letters on record, each of the 7-day notices.
Shah, the difficulty why I am against you prima facie on the first limb is that the first limb does not improve the situation for you in the sense that the contract clauses otherwise remain the same. Everything, including clause 62, remains applicable. They are not imposing any further condition, and they are only extending, postponing rather the last date. So if the last date is postponed even today, even tomorrow, if I give a notice and say, technically, they are not debarred from.
Lordship will kindly have a look. The argument which I had made while getting the interim order, Lordship will kindly have a look at that, because had it been their case that they could have terminated on any other ground other than this ground, this could have been fine. Lordship will kindly have a look at the order dated 18th October. I'll read that order once, Lordship. In terms of the tender notice dated 16 June 2017, the petitioner was granted the contract by the respondents for design, drawing, supplying, erection. Such necessary agreement was executed on 5th February 2018. Since the petitioner failed to comply with the time stipulation provided under the parent contract for carrying out its work in terms of the request made by the petitioner, such stipulated time under the contract was extended from time to time and at least 8 times. The last of such extension was made on 27 July 2022. On a close scrutiny of the letter of extension, it appears to this court that the extension was made by fixing the completion period of the work up to 31st January 2023 without any liquidated damages. The respondents, while extending time and issuing the said letter, also made it clear that the terms and conditions of the contract would remain unaltered during the extended period from 1st August 2022 till 31st January 2023. It was also mentioned that no increase of additional rates and claims of recoveries which have not already envisaged in terms and conditions of the contract would be leviable either by the petitioner or by the purchaser in respect of the extended period. Save as this, there was no other condition imposed for extension of the said letter of extension dated 27 July. Learned Counsel, appearing for the respondents, drew attention of this court to the correspondence exchanged from time to time by and between the parties to show that despite such extension, the petitioner failed its obligation in terms of the contract, and there was no attempt on the part of the petitioner to carry out and execute the contractual job. He then drew attention of this court to the various correspondences, wherefrom it would be evident that in strict compliance of clause 62 of the contract, the respondents terminated the contract granted to the petitioner. It was also submitted that in course of the exchange of the correspondence that the petitioner specifically undertook to complete the balance foundation work by September 2022, which as would be evident from the letter of the petitioner dated 3rd August 2022. The learner submitted that in addition to the facts that he has submitted, there is an existing arbitration clause and the petitioner should not be entertained. After considering the rival contentions and on perusal of the records, court is of the firm view. In fact, in this case, an alternative remedy of arbitration, which is a contractual remedy, cannot stand in entertaining the writ petition at this stage. The last letter of extension dated 27 July 2022 stipulates no further condition for extension, and it was an unconditional extension till 31st March, January 2023. The case of the respondent is also not that the ground for termination was anything other but than non-completion of the work. This is what I am on, Lordship. Non-completion of the work within the said time stipulated by virtue of the extension granted by it. On the contrary, from the record, it also appears that the termination was on the ground of non-completion of the work within the time stipulated mentioned under the contract, and also in view of the fact that the petitioner failed to carry out and execute the work within the period as undertaken by them. Considering the prima facie case at this stage for granting of an order of injunction, sole consideration should be the last letter of extension by which the time was unconditionally extended by the respondents, and there was no charges for breach or any other terms as against the writ petitioner for termination of the contract. Rest, Lordship, the injunction. So, Lordship, again, falling back on what I was arguing, the extension was based on my request for extension, which was prima facie because of their fault, and on their part, on their breaches, which I could not complete the work, attributable to them.
This was a subsequent cause of action under clause 62. After they gave the extension, the date was postponed. Definitely, you got the extension. That period was there.
Yes.
That period was never disturbed by it. They did not recall that extension.
Yes.
But these are subsequent cause of action under clause 62, alleged cause of action,
Right.
under clause 62, on which they gave us 7 days notice. Let us ignore the first 7 days notice because those were waived by themselves.
Yes.
The last 7 days notice is there as per the term of the clause 62. After that 7 days, they waited for further 7 days, gave this 48 hours notice. And after that, they have terminated after the 48
Now, Lordship, then let us go back to the notices.
I think it would be better for you if previously at the first stage, Justice Roy had given you the option of going to the arbitrator, because this is a actually you might have made certain allegations also.
Arbitration, we will go with regard to damages and all that. This is a separate aspect.
This is another aspect. There is another aspect of the matter, Mr. Shah.
Yes.
The difficulty is here. There is a dispute as to whether you actually failed to commence the work.
Right.
Because that is on facts.
Right.
Totally on facts.
Right.
Because clause 62 itself, whether that is applicable or not, that may be a debatable issue. But their non-compliance writ court interference scope is very limited. I can say at best the best order in your favor would be, rather against you, but in your favor in a sense, could be that there is no scope of interference in this writ petition. First of all, the interim order does not bind at the final stage. I'll give my reasons also. That writ court, there is no occasion because there is no irregularity in the decision-making process. This is in compliance of clause 62. 7 days notice was there, 48 hours, and these 7 days in between, that I'll say is a reasonable period. But on merits, parties can go to arbitration to dispute whether clause 62 was applicable on merits at all, on facts. That is the best order you can get here.
Lordship, before proceeding in that aspect, may I, Lordship, take your Lordship to the 3 notices? Because Lordship is now concentrating on that last 7 days notice and the 48 hours notice. Lordship will kindly have a look at that notices once. Thereafter, I'll leave it to your Lordship.
The previous notices?
No, second 7-day notice. Because the Lordship is proceeding on the fact that
now only two notices become important. One is the last 7 days notice,
yes,
and the 48 hours.
Yes, let us come back to that second last 7-day notice, Lordship. Lordship, it is at page
180. You said
yes, 180. In connection with the above subject work, we have instructed.
Read the entire things.
No, I'm reading the first paragraph because why I'm reading, this has been dealt by me in my letter of at page 181. So that is why.
That's a factual dispute. I have to keep it open. We don't know on facts whether you actually were guilty of non-compliance.
That is why I was going.
No, on facts, I have that is the issue specifically on which I want to keep it open for arbitration, subject to what Mr. Chakraborty says. That has to be kept open.
The only difficulty, I am very open to your lordship's suggestion. I bow down, lordship. The only difficulty is the bank guarantee that has been invoked.
Rightly so.
The only difficulty is that, lordship. Otherwise,
that invocation will be subject to what are they? The railways.
Railways. I have already finished the work.
I have with your money. I mean, whatever amount they have taken, I mean, that will be subject to, that will abide by the result of the arbitration. That has to. Let me hear Mr. Chakraborty.
One thing I am now willing to say. There is no agreement or contract to the effect that we shall not be able to terminate the contract even within the extended period.
Yes, apparently, yes.
Kindly come to clause 61, which my land friend has not placed at all. Of the contract, at page 90.
Yes.
Right of railway to determine the contract. The railway shall be entitled to determine and terminate the contract by any time should, in the railway's opinion, the commencement of work become necessary when the paucity of funds or from any other cause, wherever which is the case, value of the approved materials of site and the work done by date of the contract will be paid in full at the date specified in the contract notice in writing from the railway of such termination, and the reasons thereof shall be conclusive.
Mr. Chakraborty, this is independent of 62.
Independent of 62.
This you have not resorted to. You have specifically quoted 62 and taken resort to that.
But one thing kindly consider that this particular contractor was given 8 times extension.
No, those factors remain, Mr. Chakraborty. There is no dispute. I cannot enter into that dispute at this stage. And you can very well give a go by to the previous 7 days notices. You can always waive it and give another notice.
Yes.
That is your prerogative. On that, I am not at one with Mr. Shah. But on the other aspect, factually, whether they are liable to be terminated under clause 62, that is probably the a fit subject matter for arbitration.
Yes.
So I'll do that only.
The arbitration clause is extensive.
Arbitration clause, I'll resort to that. I'll say arbitration clause. Yes, I have seen the arbitration clause. I'll give you liberty to approach arbitrator on the factual issue, but I'll not direct you to repay the bank guarantee amount.
That has been encased by the bank. We have instruction.
That will abide by that amount will abide by the result.
Yes.
Lordship, the only request that I can
that
make.
was prior to the interim order.
The interim order was on 18th, it was on 16th. And that is what an instruction is.
How could they know? Yes.
Yes. Now, the only prayer I am willing to go to arbitration. There is no difficulty, Lordship, because the work is completed. Now, in the arbitration, Lordship will keep everything open then.
Everything cannot be kept open.
Because I have a claim for damages as well.
The issues will be kept open.
Yes, all issues are kept open, Lordship. And the writ petition has been entertained, Lordship, because the point that might be taken in the...
Yes, I've seen that. No, I've seen that. That is precisely, Mr. Shah, I could not make myself very clear to you. I will have to say in my order, I'll have to give 2 protections to you. One, that you can approach the arbitrator on factual aspect of violation of 62. One. Secondly, writ court admitted on the ground that arbitration clause is not an absolute bar.
Yes,
but even then, even if it is not an absolute bar, that is at the point of entertaining the writ petition, that was valid. But after entertaining and hearing it on merits, we have to look into the factors, whether you satisfy the window of interference under 226. That is irrespective of the arbitration clause.
Absolutely.
Therefore, arbitration, my reference to arbitration will be an additional advantage to you.
Yes. That
in other circumstances, you should not have got that after that order. So that protection I am willing to give to you. Yes, Mr. Yes, your both sides are there. Both sides are there. I'll pass my order immediately, but act order, this is 9.
Mine is 9.
9 act order record.
I've given a
Oh, yes, Mr. Item, I'll pass my order immediately after 9. Item 9, the matter is taken out of turn on the mentioning of parties, comma, since both sides are ready to file the written notes of arguments, full stop, such short written notes of arguments filed by the petitioners and the respondents be kept on record, full stop, the matter is reserved for judgment. Respondents are also filing?
Respondent has already filed.
Already filed.
The direction was only upon us.
Very.
Grateful, Lordship.
Acha, I'm now passing my order on your matter. Other matters are released. Nothing remains.
Small request I had.
No, I'm in the midst of a matter. Heard learned counsel for the parties. এটা হচ্ছে আপনার যেটা শুনছিলাম সেটার হ্যাঁ heard learned counsel for the parties. First up, learned counsel for the petitioner contends that several extensions were given to the petitioner, to complete the work contemplated under a contract awarded to the petitioner by the railway authorities. First up, the last such extension clearly mentioned the last such extension granted on
page 188.
Granted on July 27, 2022 clearly mentioned that the terms and conditions of the contract would remain unaltered during the extended period from August 1, 2022 to January 31, 2023. Full stop. It was further stipulated that no increase of additional rates and claims of recoveries which had not been already envisaged in terms and condition of the contract would be leviable either by the petitioner or by the purchaser in respect of the extended period. Full stop. It is pointed out that it was further stipulated in the said communication that the grant of extension of completion period up to January 31, 2023 was without any LD, within bracket liquidated damages, bracket closed. It is contended that soon thereafter, by a communication and by several communications, the respondent authorities started to invoke clause 62 of the standard general conditions of contract, eking the contract, egging on EGGING the petitioner to commence works to make good the progress, failing which, in terms of clause 62, the respondents would allegedly terminate the contract of the petitioner and complete the balance work without the participation of the petitioner. Full stop. It is submitted that several such letters were issued by the respondent authorities, the last one being on September 15, 2022. Full stop. However, no follow-up steps were taken by the respondents on the previous letters. Full stop. However, 7 days after the expiry of the stipulated period of 7 days subsequent to the September 15, 2022 communication, a notice was given to the petitioner on September 29, 2022, giving the petitioners 48 hours, apparently in terms of clause 62, to commence the works or to make good the progress of works, failing which the respondent indicated that the contract of the petitioner would be rescinded and the work would be carried out independently without the petitioner's participation, and that the security deposit would be forfeited and performance guarantee would also be encashed, and any other consequences may follow. Full stop. Next para. It is argued that the respondent authorities acted dehors the law and in violation of natural justice in terminating the contract of the petitioner much prior to the expiry of the extended period, which was to take place on January 31, 2023. Full stop. Next para. It is further argued that even in terms of clause 62 of the general conditions of contract, it was the incumbent duty of the respondent authorities to issue the 48 hours notice contemplated therein immediately upon expiry of the stipulated period of 7 days upon the first notice being issued under clause 62. Full stop. Having not done so, comma, it is submitted that the 48 hours termination notice issued by the respondents is vitiated by the terms of the contract itself. Full stop. It is further alleged that, comma, if notionally the respondents were allowed under clause 62 to take as much time as they wished to follow up the 7 days notice under clause 62, comma, for the purpose of issuing the 48 hours notice, comma, the respondents could very well come up on a stale, S-T-A-L-E, stale cause of action, comma, much after the issuance of the 7 days notice, comma, despite the petitioner having substantially undertaken and or even completed the work. Full stop. Hence, comma, the interpretation as sought to be lent by the petitioner, comma, it is argued, comma, has to be given to clause 62. Full stop. Next para. Learned senior counsel appearing for the respondent authority submits that as many as 8 extensions were given to the petitioner. Full stop. That apart, comma, it is contended that the extension was given to the petitioner without prejudice to the rights and contentions of the respondents to terminate the petitioner's contract, comma, as envisaged in the original contract. Full stop. That apart, comma, learned senior counsel also places reliance on clause 61 of the general conditions of contract, comma, which also stipulates that the railway authorities shall be entitled to determine and terminate the contract at any time if, in the opinion of the railway, comma, the cessation, C-E-S-S-A-T-I-O-N, cessation of work becomes necessary owing to paucity of funds or any other cause, whatever. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is seen that the writ petition was initially entertained by a learned single judge of this court during vacation, comma, inter alia on the ground that the arbitration clause provided in the contract is not an absolute bar to the interference of the writ code. Full stop. It was specifically observed that the court was of the firm view that in the facts of the case, comma, an alternative remedy for arbitration, comma, which of course is a contractual remedy agreed upon by the parties, comma, could not stand in entertaining the writ petition at that stage. Full stop. Next para. As is obvious from the order itself, comma, the fact that the writ petition was entertained on such premise does not mean that a different order cannot be passed at the final hearing of the writ petition, comma, upon a full consideration of the merits of the writ petition. Full stop. That apart, comma, even the said order of the coordinate bench stipulates that the writ petition was being entertained at that stage. Full stop. Next para. The petitioner, comma, in any event, comma, has to pass the limited window of interference in a writ petition. Full stop. In the present case, comma, insofar as the first argument of the petitioner is concerned, comma, the same cannot stand on good ground, comma, in view of the specific language of the extension granted to the petitioner by the respondent. Full stop. In the communication regarding extension dated July 27, 2022, comma, although it was stipulated that the extension was without any liquidated damages, comma, the same was confined only to such liquidated damages, comma, for the purpose of grant of such extension. Full stop. However, comma, the last paragraph of the same communication clarified that the terms and conditions of the contract would remain unaltered during the extended period and no increase of additional rates and claim of recoveries which had not been already envisaged in terms and conditions of the contract would be leviable either by the petitioner or the purchaser in respect of the extended period. Full stop. The net effect of such provision is that the terms of the original contract held good, comma, having remained unaltered even during the extended period. Full stop. The effect of the extension of the outer limit of completion of the contract was merely to postpone the last date of completion of the contract work. Full stop. Next para. However, comma, all original conditions of the contract, comma, including clause 62, comma, remained intact insofar as the parties were concerned. Full stop. Next para. Although the argument of the respondent authorities regarding applicability of clause 61 of the contract cannot be accepted, comma, since the respondent authorities clearly invoked clause 62 as indicated in their communications, comma, and chose not to invoke clause 61, comma, it is clause 62 which is to be considered in the present case. Full stop. Even upon a consideration of clause 62, comma, it is seen that at least two sub-provisions thereof, comma, being clause 62 within bracket 1 within bracket small Roman 7 and small Roman 8 are German. Full stop. The first provides that if there is persistent disregard of the instructions of the engineer or contravention of any provision of the contract, and the second provides that if there is failure on the part of the contractor to adhere to the agreed program of work by a margin of 10% of the stipulated period, comma, could justify the invocation of clause 62 for termination. Full stop. Next para. The last paragraph of clause 62 within bracket 1 clearly provides that a prior notice had to be given for a period of 7 days after the delivery of the notice, comma, for the contractor to make good his default. Full stop. In the present case, comma, the respondent authorities waited for 14 days after the issuance of the notice before taking further steps in the matter. Full stop. Such additional period of about a week was, comma, obviously left to leave no manner of doubt as regards the delivery of the notice prior to taking steps following the same. Full stop. Hence, comma, since the follow-up steps of issuing a 48 hours notice was taken within a reasonable period thereafter, comma, it cannot be said that the respondent failed to invoke the provisions of clause 62. Full stop. Next para. Hence, comma, insofar as the decision-making process of the respondent authorities is concerned, comma, I do not find any violation of the stipulations of clause 62 inasmuch as a preceding notice of 7 days was given and only after delivery of the same, comma, leaving 7 days thereafter, comma, a 48 hours notice was issued for termination of the contract. Full stop. Next para. Hence, comma, per se, comma, there is no irregularity or illegality or violation of natural justice and or contravention of any gross contravention of any provision of the contract between the parties insofar as the termination is concerned. Full stop. Accordingly, comma, the consequential invocation of the bank guarantee by the respondent authorities cannot also be faulted, comma, being a fallout of the termination.
But these observations will have.
No, not. As far as the invocation, as far as the allegation that the invocation was done in contravention of an interim order passed by the court is concerned, comma, it has been argued by the respondent authorities that the invocation was made 2 days prior to the passing of the ad interim order, full stop. In any event, comma, the said amount, comma, covered by the original bank guarantee issued by the respondent authority, by the petitioner, comma, shall abide by the outcome of the arbitration proceeding, comma, if any taken out by the parties. Full stop. Next para. As such, comma, it is clarified that since this court, comma, being a writ court, comma, refused to interfere in the matter in the absence of any gross illegality and or abuse of the process of court, and or in the absence of any patent arbitrariness or malafidis on the part of the respondent authorities, comma, nothing in this order shall preclude either of the parties, comma, including either of the parties to approach the arbitrator agreed upon by the parties in accordance with law, comma, for a resolution of the factual dispute as to whether the petitioner could be said to be liable for termination of its contract and the consequential actions taken by the respondent on merits, comma, upon a consideration of the factual premise in the context of clause 62 of the general conditions of contract. Full stop. It is beyond the scope of the writ court to enter into the detailed query on examination of evidence as to whether, comma, on facts, comma, the respondent was justified in invoking clause 62, comma, insofar as the alleged violation of the said clause by the petitioner is concerned. Full stop. Hence, comma, it will be open to the parties, comma, as indicated above, comma, to take all issues before the arbitrator, comma, if the parties so choose, comma, with regard to the question of whether the petitioner is guilty of violation of clause 62 of the general conditions of contract on the facts of the case. Full stop. In view of the above observations, comma, WPO number 2848 of 2022 is dismissed, full stop. However, liberty is granted as per the above indications, comma, to the parties to invoke the arbitration clause in the contract in due process of law, in the light of the observations made above. It a repetition in the light of the observations.
Only one further observation, that the arbitral tribunal will not be persuaded by the observations made in this.
It is further clarified that the arbitral tribunal, comma, if so moved by the parties, comma, shall arrive at its findings independently and in accordance with law without being unduly influenced in any manner by any of the observations made herein, comma, as far as the merits of the disputes are concerned. Yes.
And I have a very innocuous prayer, my lord. I had a bereavement in the family, my lord. I will not be available on 6th and 7th. So next matter, my lord, can retain its position tomorrow so that I can do the matter tomorrow. Next matter. Item number 2.
Immediate written position. Yes. Is there any apprehension it will not retain its position? I have not reached it as yet.
No, but the thing is that 6 and 7, I am not here. So
very well.
I'm grateful.
My lord, may I request, my lord, item 11, my lord, it was heard last Tuesday, in last 10 minutes, and more or less I have completed my argument. So if it can be kept a little higher on the board tomorrow.
If you want, I can hear it the next Tuesday again. If Tuesday is a good day for you.
No, that's not the thing, my lord.
I'll take it up whenever I can.
Because my
all 3:30s, I can be, I'll be able to take up the matter. Today, due to the 3:30, I cannot take up the matter.
Right. Grateful.